All right, everybody. Well, look, it's I know it's late in the evening, but I appreciate everyone being here for the first meeting of the Special Committee on Access to the Civil Justice System. I want to start by saying I appreciate the speaker for placing his trust in me to chair such an important committee, and I want to thank the members who are willing to serve on it. We have 5 bills on our agenda for today. My understanding is that Representative Momtahan has brought a constituent with him who has been waiting patiently as we've had a long floor debates today, and then as we got held up in the Health Committee. So I'm going to call House Bill 1101 first. I do want to say that today we're going to take an opportunity to hear all sides of these measures. We will have another meeting on Thursday. At that time, we will be taking action on a number of measures. And for any amendments that will be proposed by the committee, I'll ask for those to be submitted in writing an hour prior to the meeting to be considered at that time. I would also ask all comments today to try and be limited to the language of the bill and specifically to that. Several of these measures have been seen in one form or the other throughout this legislature, and we will be taking that into consideration as we consider the length of discussion that takes place today. All right. Representative Momtahan, talk to us about House Bill 1101.
Is this thing working? Thank you, Mr. Chairman. Let me get my notes here, Mr. Chairman. If you will, would you like my constituent to?
Just introduce him, please.
Okay, Mr. Chairman, this is my constituent, Mr. Robin Stern. He is here today to testify to the bill and to the genesis of where this language originated from. Let's see. And Mr. Chairman, would you like him to?
Yeah, sure.
Okay, I'm going to have him start and kind of tell you the genesis of what happened. Mr. Stern, if you will.
This one works. Oops, I guess it does. Well, thank you very much.
Thank you for being here.
You're very welcome. Thank you, sir. I'm a father of 3 boys, a former Marine, and I serve in many areas of my community, Chamber of Commerce, Workforce Development, as well as the executive director of a local nonprofit that serves Boys and Girls Club members in Paulding County. I serve in my church, and I fully believe and trust the legislative process in our great state of Georgia. I asked to be here today. When I contacted my local representative, Martin Momtahan, and told him this story, he said they were working on something like this and that there might be an opportunity for me to be able to tell this to a committee that could maybe do something about it. I got a call a few months back, late in the evening. My son has a 97 Honda that he was at a homecoming dance at the school, and I got a call from the Paulding County Sheriff's Office asking me if I own this car. And I said, of course, but I was a little freaked out at the point. They told me there was no problem. They needed me to get a hold of my son because they couldn't get a hold of him, and he was in the dance. I'm the registered owner. They contacted me. So we got him out there. He talked to the sheriff. The gentleman who hit his car contacted the sheriff's office, filed the report, contacted his insurance company, filed a claim, gave us the information, did the right thing. It all started when I contacted the insurance company and said, hey, we have this. Oh, no, I'm sorry. I got called the next morning at 8 a.m. by the company asking me to release my car. I said, why would you want me to release my car? Well, we're here to pick it up for salvage because it's been totaled. Why is my car totaled? Well, it's going to cost more to fix it than it's worth. Well, who makes that decision? Well, the insurance company. So I was asked to release it. I said no. This was less than 12 hours from the accident time. They were calling me up early in the morning, really trying to tell me this is the way it works and this is how it goes and this is what you have to do. I said no. You can't take my car. That's not going to happen. And I went and got it. And my son is still driving the car with a piece of red plastic over the taillight. The only thing broken on the car was the taillight. There was no other damage to the vehicle. They totaled the car for a $68 taillight. So I called the guy and I said, what's going on? Very helpful. Young man with USA. Very helpful young man, walking me through, this is what we're going to do. This is the amount you're going to get. And you just have to sign the paperwork and send us the title. I said, wait, what about the car? I need the car. He says, no. We get the car. The car's totaled. And you get to take the money, which was about a third of what we had involved in the vehicle. So I said, well, that's not going to work. We have to be able to be made whole. We need to replace the vehicle. Well, they were said, we are only liable for the value of the car based on our system. So we've punched in the numbers, we've compared it to comparable vehicles, this is what it's worth, minus the wear and tear, and you can get $1,100. We had about $3,000 in the car at that time. A lot of my 17-year-olds sweat and blood. I explained that we had the money in it, and he informed me they were only obligated to pay me the value of their system. So I tried to explain that we needed to be made whole, and he said, there's no way they could replace our car. I said, there's no way we can replace the car for $1,100. And now he's still trying to make me feel that he's helping me at this point. And I asked him, how can I be made whole? He said that they're only legally obligated to pay me for the physical loss, and the car is only worth $1,100, so that was all they could give me. Now the conversation takes a palpable turn. I mentioned I may need to hire some professional help to figure this out. This is the part I think we're here for today. The young man informed me that no good attorney would take my case as there was no bodily injury. And if I did decide to retain an attorney, he got quite antagonistic at this point, and he informed me that I would just have to get less of the $1,100 settlement because the attorneys would get part of the settlement. I have to pay them part of that $1,100 to have them represent me. So I asked why he was being so antagonistic and defensive, and he took a very ugly tone and told me that I was only due the physical loss, my car was totaled, and even if I did nothing, I now cannot sell that car because it now has a salvage title. It's totaled for a taillight. I come here today to share this info with you, not for myself. I can replace the vehicle for my son. I didn't come here for my son. He has me to help him and support him. I come here today for the single mom who doesn't comprehend the process and takes the $1,100 thinking she'll be able to fix her car and get on with life, only to find out they're going to keep her car, and now she has $1,100 and no way to get to work, take her kids to the doctor, or get them to school. This is a travesty being perpetrated on your constituents. The lowest members on the income and educational totem pole are the ones who are getting hurt. Something has to be done. Not only do I support the passage of this bill, but I respectfully request that this legislative body would open the dialogue to discuss specifically the idea of making the injured party whole. Just because the insurance companies have a right to go by the accepted systems and come to evaluation of a totaled car doesn't make it right. Ladies and gentlemen of this distinguished legislative body, I thank each of you for your willingness to serve this great state of Georgia, and thank you for your time.
We certainly appreciate you being willing to come up here today and spend your time with us and share the personal experience that helped lead to this legislation.
Thank you.
At this time, I'd like Representative Montahan to walk us through the bill.
Yes, thank you, Mr. Chairman. Mr. Chairman, we'll walk through this section by section. As we get to, this is LC 412230. Make sure we're on the same page here. Section 1, it says insurance companies are required to disclose certain information upon receipt of a claim within 60 days. But there's really no penalty. So what we've done here is we've changed that. And so what we've said here is that prior to making a settlement offer contemporaneous with such settlement offer, every insurer providing this kind of insurance has to give the information within 14 days. And so why is that? If we have somebody who's been damaged, okay, whether it's physical property or it's a person who's laying in a bed somewhere, let's just use the example that I'm in a hospital, okay? These folks need to have the understanding, right? And when we talk about and this is going to be claimed asserted onto the next page about the name of the insurer and who's insured and all that, people have to know if they're going to be insured. They have to know, right, this kind of information so they can make decisions about their health. That is a very important portion about this. That way a doctor or somebody who's in a healthcare facility does not say, this person doesn't have insurance. We're going to take an alternative method of treatment, right? It's important that there be some expedition here, expediting factor when we deal with this kind of the return, the time that we have to get this back. Ladies and gentlemen, we have to have that. when we talk about the information, you look through the rest of section, which is lines 27 throughout here, we talk about what is effectively a declaration page. Okay, that's going to be the details about the accident, who is involved. We're trying to get to the bottom of it just as quickly as possible. You see under line 55 here, the following statements, which shall reference the policy number, claim number. You may seek representation by an attorney to ensure that your interests are protected during this claim process. We go through, and this is going to be line 60 through 66. You may seek representation, and then 67 through 72. Will your insurer required to treat your financial interests as at least equal to that of your own financial interest? We bring that through line 73 and 74. Please know that pursuant to OCGA actions, let's get to the heart of the issue. My constituent brought this to me because he was bulldogged on the telephone by his insurance company. He was told that, sir, we're going to close this claim. Even though under this code section, he has the right to bring a claim himself because he was the one that was damaged for 4 years. Yet, it is open season on people who are damaged in our state that may or may not understand the total environment in which they are currently operating. And so I think it's important as a consumer protection measure to make sure that constituents, residents, consumers in our state, who if they wish to operate a motor vehicle in our state, they're required to purchase this insurance. If we're going to do that, they ought to have a right of notice, that they can seek representation. They ought to have the ability to have somebody represent. So if I'm laid up in a hospital bed, that my spouse, okay, can ask for declaration pages. They ought to have the ability to know how long they can make a claim for. I think that's important. If you see on line 75 through 79 here, please know that pursuant to OCGA, that a personal injury claim must be brought within 2 years, right? This is important information. And the faster we can get this into somebody's hands, so 75 through 79 here, it's important that these constituents, these consumers, have the ability to know what they're getting into. More than likely, now let's set this up here, more than likely, these folks have been either paying for insurance for 5, 10, 15, or more years. And they may have never utilized it. But I think the feeling is that the second they try to use something that they have to purchase, it's not there for them. And I think that's the policy decision that we're making today. We add a little teeth here, right? We say that insurance failure to comply with subsection shall give rise to a claim of negligence or bad faith. It may give rise to damage to equitable relief. That's under 80 and 81, subsection C. And on the back page, any person who is injured as a result of the acts provided for shall have a private cause of action. That's the teeth. It says that in Georgia, as a consumer of insurance, that you can't bulldog a constituent. Now, he's a relatively young man. But I've heard stories after stories of the elderly in our state that are coming under this kind of attack. And let me tell you, my grandmother, I wouldn't want her to be treated the way that my constituent was. Mr. Chairman, that's the genesis of the bill. That's the gist of the language that we have here today. And with that, I'll end my presentation.
All right. Thank you so much, Representative. Just so I'm clear, just kind of walking through the bill, we start out with a kind of a shortened timeline to allow for insureds to get some notification in a more timely manner, and that continues to go down, starting down to line 54. Starting at line 55, it's my understanding that you make clear that the consumer, the insured, should be notified that they can always seek representation to help assist with this claim. Back on line 60, we again start talking about getting knowledge in a timely manner. Then we again get down to some notification. Line 67 through 72 is what I would refer to as a conflict of interest protection language. Line 73 through 74 helps our insurers and our consumers understand what the statute of limitations in Georgia, and that goes from 73 down to 79. And then finally, lines 80 and 81 deal with the cause of action, as well as 97 through 99. Is that how you understand it as well?
I understand to be that, Mr. Chairman.
All right. Let's take some questions from the committee. First, we'll recognize our chairman of the Judiciary Committee, since he's allowing us to use his room here. Mr. Chairman?
And I told everybody before you got here, Mr. Whip, that we had called the building people about the heat in here, and Casey has not talking as much, and it's getting a little better. So I just want to make sure I have my facts straight in the story that you told, sir. And I'm sorry you had the problems that you did. USAA is your insurer. That was it.
Who hit us?
That was the other. So this was not your insurance company you had the problems with. It was the other guy's insurance company. I misunderstood that. Now, Mr. Chairman, I have questions about the functioning of the bill. I don't know if you want us to address those at this time, or you want to wait for more witnesses, because I suspect other things will be drawn up. I'm turning to you for guidance.
No, I think we'll take further testimony. We'll take initial questions for the representative who presented the bill, and then we'll draw up additional witnesses as well.
Well, I'll hold for now then.
All right. Any other questions for the witness or Representative Montagne? All right. Why don't y'all just, Representative Montagne, you can just slide over. If you'd like to grab a seat, you certainly can do that, sir. Thank you for being with us. Thank you for sharing your story, and thank you for...
Yeah, Mr. Chairman, I don't mean to cut you off, but he's been very patient today. I was going to let him go if that's okay with y'all.
Unless you need me.
That's fine. No, we appreciate you being here. We appreciate you helping effectuate good public policy in Georgia. Thank you.
Thank you for your time.
Thank you, my friend. Have a good one,
Yep.
okay?
Take some more of the heat out of here. Please.
All right. I can't quite make out the names, but I have two individuals from State Farm that would like to come and speak. Are y'all agents or attorneys? Because the handwriting looks like attorneys.
Well, I'm an attorney, and I did write it. Thank you, sir.
I am not an attorney or an agent. I'm an employee of the company.
All right. It was great to have y'all here with us. State your names for us.
Yeah, thank you, Mr. Chairman. My name is Mark Tilken. I am counsel for State Farm.
My name is Todd Bevel. I am a claims section manager with State Farm.
All right. Thank y'all both for being here today.
Thank you, Mr. Chairman. If I may, can I just give a little background on State Farm and the presence in Georgia? Because I think it could be important. We've been growing in Georgia. State Farm has over 11,000 agents, agent team members, and employees who work and reside in the state of Georgia. We have approximately 1.8 million auto policies in force in the state of Georgia. We pay over $1 billion in claims each year in the state of Georgia. We pay $75 million in premium taxes. We give back to the community, $10 million in charitable giving last year, along with charitable giving and an arrangement with the Georgia State College to invest in their students. So we have quite a presence in the state, and we are happy to be in Georgia. We wanted to speak about this bill, and I don't usually like to testify, but this bill is incredibly serious to us. By the way, my background, I've been with State Farm about 25 years. I was an insurance defense attorney with State Farm. I've been in claims management with State Farm, and I'm currently in corporate law with State Farm. If this bill is passed as is, it really has the potential to make claim handling in Georgia almost impossible. Currently, the law allows or provides 60 days for an insurance company to give the insurance information, and then 30 days for insureds to give information about other insurance. This law would require, in a very short period of time, 14 days, an insurer to give information largely with information that is not in the possession or control of the insurance company. And quite frankly, not sure how we would go about getting it. I'm going to let Mr. Bevel is a claim manager with State Farm. I'll let him talk about that a little more.
I would just note that these bottles of water look suspiciously cool. Very kind, thank you. I wanted to start out by saying, with respect to Mr. Stern, I apologize for that. I mean, we're not with USAA, but everyone should have their claim handled appropriately. At State Farm, we handle thousands of claims a year. I've been with the company for 34 years now. I've worked in multiple states, but I've been here for about 10 years now. And in my 34 years with the company, this is probably the most consequential piece of legislation I've seen affecting the insurance industry. It's that consequential. Everything is wrapped up in a time period of 14 days with information requesting us to provide information that we don't have. We would be entirely dependent upon getting that information from others who may or may not be in the possession of it, and it's all wrapped up in an umbrella requiring us to get it within 14 days. And if we do not get it within 14 days, the potential consequences for that could be very, very significant, not only for State Farm, but for our customers, for our policyholders here in Georgia.
So I'd like to add that the information, and some of the information is the employer and who the employer's insurance company is, other people and who their insurance company is. That is information that we may or may not be able to get, certainly would be difficult to get in 14 days. I will tell you, State Farm handles hundreds of thousands of claims in the state of Georgia every year, about 1,000 a day. So it would, in my opinion, grind claim handling to a halt. And not only that, it would open up potentially every claim where we couldn't get one piece of information that's required to a finding of negligence or bad faith. And that is not a determination that would be made by a judge or a jury. That is, in the legislation, it indicates that if we don't give that information, it shall be negligence or bad faith. And that would lead to a major increase in litigation, a major increase in the costs to do business in the state of Georgia. And I would imagine for big companies and small companies alike, it would make it almost impossible to handle claims. And I don't think anybody, I don't believe that's good for anybody. The insurance industry, the trial lawyers, our customers, it's just, in our opinion, not good policy.
As we're focusing on the legislation before us, could you point to the items in the bill that you think you would have problems getting within the 14-day timeline? Just help us identify those.
Sure. You could really go down the list starting at around number 41, because 41 is really where it starts broadening what the current statute is. Whether the insured was acting within the scope of any business or employment when the incident occurred, we don't always know that. A lot of times we do, but we don't always know that. The name and address of the business or the place of, it could be an incorporated business, it could be a doing business as type entity. From an insurance perspective, that has ramifications, and that needs to be vetted out, and a lot of times that's not easy to discern. Resident relatives who own a motor vehicle, you would be surprised at the number of families in the state of Georgia where relatives have different last names. We see it on a very frequent basis, and it takes time to vet through that information. Whether the insured owns any motor vehicles, and if so, the year, make, and model, and the insurance carriers for those motor vehicles. I can speak to State Farm and who State Farm insures, but I'm not in a position to speak to who Progressive, Geico, or any other carrier might insure. That would be a problem for our claim handling. The name of each known insurer which may be liable to the claimant upon such claim, we don't have any way of knowing that information. So on a number of different levels, we find the legislation to be very problematic and frankly, borderline impossible for our representatives to handle.
All right. So for the committee, I marked that as letters B, D, E, and G. I noted that right. I also do want us to make sure we look at lines 82 through 89 too, because I feel like that may give us an opportunity if some information is not able to be gathered or to be able to delivered within the timeline to state so in writing, stating specifically what additional information is needed. Does that address any of your concerns there? The fact that if you can't get it, you can just put it in writing and submit it with the other?
Yeah, Mr. Chair, I guess one of my concerns is with the 14-day requirement, then that would always be a question of whether we could or could not have gotten it within 14 days, which I think would be a problem. The other thing is there's some of this information that we may never be able to obtain. If an employer did not want to give us the name of their insurance company because they don't feel that they are in any way responsible, we have no way of knowing what the name of that insurance company is. The broad language of any insurance company that may be liable, that could come never, or it could come after years of discovery if a lawsuit was filed. Sometimes through discovery you learn of additional information. But to get that information within 14 days or even through the course of a normal claims investigation would be, I think, very difficult, if not impossible. I do want to talk about Mr. Stern also. I mean, unfortunately, some things happen. We strive to treat every customer the way we would want to be treated. And I think we do a very good job at State Farm. There's a Department of Insurance that deals with issues like that all the time. Mr. Bevel deals with complaints that are made to the Department of Insurance. I deal with complaints that are made to the Department of Insurance. And I would say that we managed to resolve, if not all of them, significant amount of those complaints. So there is a mechanism in place if an insured is not satisfied with how their claim is going or what is happening during the claim. The Department of Insurance happens to be very good and, quite frankly, aggressive in making sure that insurers are doing what they are required to do.
Just a couple of points I would add to what the chairman offered is that line 84 where it says may so state in writing specifically what additional information is needed, or an insurer's failure to comply with subsection A or B of this code. Who's going to make that decision? Who's going to decide, okay, this is a failure and this is a not? That issue will ultimately be litigated, and it'll come down to some kind of decision, which is going to cost a lot of money. I would suggest that at least in this area is ambiguous, it's unclear, the responsibilities remain unclear. Mark talked about our relationship with the Department of Insurance, but I would just tell you, as someone who has handled claims for 34 years, I have responsibilities for a number of teams right here in Atlanta. I talk to policyholders every day, not necessarily the Georgia Department of Insurance. I have interactions with them, but any State Farm policyholder, any claimant that we see, they have the freedom to contact me, talk to any of my representatives. So while we work with the Department of Insurance, I would even suggest that's the secondary layer. The first layer would be the conversations that I might have with them. One other final point with respect to 67 through 92. Are we okay? This appears on its surface to be, I don't want to say it's a layer of bureaucracy, but it's additional information. And when you buy insurance, you are given a policy. That policy spells out the rights and obligations not only of the insurer, but also of the insurer. We believe that contract is what is essential for making the insurance mechanism work in the state of Georgia. We would respectfully suggest that this additional language is simply isn't needed.
Do you have a problem with it though?
I do.
Can you explain that outside of it being maybe redundant?
Let me try.
Okay.
You know, the vast majority of claims are settled without any lawsuit being filed in the normal course of business. Said we handle hundreds of thousands of claims every year. Very few cases actually go to trial. This language, to me, would, I think, maybe cause some insureds to seek representation because they felt they should or had to, when they may not need to, especially in routine property damage claims or things of that nature. I think with Mr. Bell, I don't think it's a good idea. I don't think we should be encouraging to have people pay for attorneys when they don't need attorneys. If they need an attorney, they absolutely have a right and should get one. And there is no shortage of attorneys out there who let people know that they exist. But for an insurance company to say, you should get an attorney at your own expense when it may not be necessary, I don't think is good for most of our customers.
We talked a little bit about the timeline. I've heard y'all mention the 14 days. Is there any amount of time less than 60 days that y'all would be comfortable with?
Not to get this amount of information. You know, currently, information in our control, we give pretty routinely. And I think I'm maybe speaking out of turn, but you know, if somebody asks us for the policy limits or the policy deck, we usually give it pretty quick. That's what's in our control. We don't sit there and wait for 60 days to give it. We give it when we get the request. I can't say 100% of the time. There's always issues, but that's what we strive to do. So that, to me, is the information that has been historically given. I haven't heard issues with the fact that people can't get that information, and that is the information that is within our control. I guess what I'm saying is I think the current law works.
Okay. All right. Chairman Fleming.
Thank you, Mr. Chairman. One of the problems with going through a bill is trying to figure out who to ask a particular question to. So y'all are there, so I'm going to ask.
Please do.
First of all, the story that we heard that was the genesis for the representatives bringing this legislation, I wrote down it was a 97 Honda. I don't know when it happened. If it happened this year, it'd be a 23-year-old car. Said he had $3,000 in it. And it was offered $1,100. I mean, if the transmission on that car was about to go out and he was trying to figure out how to get rid of it, you know, I'm getting to the point of what if he had wanted the $1,100? As I read this on line 14, prior to making a settlement offer, prior to making a settlement offer or contemporaneous with a settlement offer, you have to send via certified mail, statutory overnight delivery, certain information. Are we precluding by this a potential claimant, if he wants to accept it, from accepting an offer?
I think that's exactly what it says. And for just with all due respect, when I leave here today, I've got a 1-year-old child at home and a 10-year-old child at home, and I'm going to get in my 15-year-old 2005 Toyota Camry, and I'm going to drive it home. And it's worth more than $1,100 to me too. But if this legislation were passed and I had a claim with State Farm, USAA, or anybody else, and they offered me $1,100, $1,500, $2,000, I wouldn't be able to accept it.
Until
Or they couldn't accept. They couldn't make the offer.
All right, let me ask you another question. I assume, and this is where I got the books I was trying to figure out, I don't know, maybe y'all can tell me. I don't think this language would only apply to automobile claims. I think it would also, I'm asking, would it also apply to a med-mal claim?
You know, I'd have to look at the code, but it doesn't look like, well, I'm going to say I don't know, because
I don't know either.
it isn't the same title as the original law, which gives 60 days to send the deck page. So I am not sure if it would apply outside of the automobile.
And the
policy.
reason I bring that up is if it does apply to other types of insurance like med-mal, for example, do we really want the claim adjuster to answer vehicles about operating cars and within the scope of business and things like that? I mean, you know,
Yes, sir.
if we pass something, I want to make sure it makes sense when it leaves here. So, but if you could find that out, that would be something I would be interested in knowing.
Sure, thank you.
Thank you, Mr. Chairman.
All right. Any more questions for the witnesses? All right. Representative Oliver.
What are the time limits of other states to produce a copy of a policy? I'm just curious. Is 60 days a normal time period, or 30 days more normal? What's around us?
60 days is relatively common. The vast majority of states don't even have a disclosure law.
What's the shortest one nationally? Do you know where y'all operate for State Farm?
I only handle a few states, and so I'm not familiar with
Yeah.
every state. I will say that no state requires anywhere near this level of information to be disclosed. It is normally your policy that applies with the name of the insured and the amount of the coverage.
And frankly, our statute as it's written now is working fine.
Chairman Fleming.
I think by your own statement, the story you heard given today was not a good one. And of course, if that's the way the facts were, it didn't sound good. And you said you hope nobody would ever treat one of your
Absolutely.
insureds that way. As an attorney, I am governed by the Supreme Court and the State Bar of Georgia with several ethical canons and other things that I have to comply with, and somebody can make a complaint against me if I don't, and you can have to have hearings and ultimately obviously be sued for malpractice. That is in some ways a form of self-policing of my profession. Doctors have similar things. I don't know about accountants. What about the insurance area? Do y'all have any form of self-policing where you try to weed out the bad apples? I'm sure you would try to fire someone who wasn't doing a good job.
Absolutely.
But what form of, do you understand my question?
Well,
What
the-
form of, is there best practices in the industry that there is some way that someone complains about what you've done? I know you can call the insurance agent. I'm trying to ask, are you in the process of trying to solve your own industry's problems, and if so, how?
Well, the Department of Insurance regulates us, and they have a whole department that does nothing but deal with consumer complaints. They have another department that deals with market conduct exams. So, for instance, the Department of Insurance will analyze the number and types of complaints that come in for any given company, and if they detect a pattern, then they can look at anything that we do. And they'll do routine market conduct exams just to make sure we're doing the right thing. And then they may do market conduct exams based on things that they may be seeing through their complaint department. So what I would tell you is I think we do a good job of policing ourselves because we do have fairly high standards. And we want to make sure that we are adhering to our own standards, but the Department of Insurance ultimately wields great authority over every insurance company that is licensed in the state of Georgia.
Well, you can't control all bad apples. We know that, just like there's some attorneys I wish that would lose their license when I've heard of some things that they did. But the more that you can convince us that you're self-policing yourself and you have industry standards and give examples of people who got rid of because they didn't do the right thing, it would make me feel a lot more comfortable. And I don't know that it would be as much impetus behind legislation like this to come forward.
Can you speak to how the public finds out about the findings from the insurance department? Are those public? Do they release those?
Yeah, in fact, the insurance department publishes on their website the complaint ratios for each company. I'll be honest with you, I don't like it a whole lot because it doesn't only say the complaint ratio, it gives the number of complaints. And we have such a large percentage of the market and so many claims and so many policies that sometimes our number looks high, but our complaint ratio is very low. So our ratio per 1,000 policies is very low.
What other information do they put out? Do they put out the types of the complaint? Do they put out the resolution? Do they put out what the what the finding was by them? And I'm wondering if maybe that's something we need to add in this to help increase the transparency on this.
I think maybe talking to them might be better. I don't know if they deal, I don't think they divulge each individual complaint and what the resolution was. If a market conduct exam resulted in findings which were in a report, I believe those are made public. So somebody would be able to look at that.
Number Chairman Efstration, who's also letting us use his committee room as well. Thank you, Mr. Chairman.
My pleasure. Thank you, Chairman Kelly. So I really appreciate the testimony. I just have a few questions procedurally, so maybe I can completely understand. So if under existing law, just no response is given, the 60 days pass, I've kind of learned and trying to educate myself about this bill, then the only real recourse that a person would have is to make a complaint to the insurance department. Is that correct?
Yeah, I believe there's a administrative penalty that could be imposed for not complying with that statute.
So if you can just explain to me how that works. So 60 days passes under existing law, and then this person would then, submit a complaint to the insurance department, insurance commissioner?
I have to tell you, I've never been involved in one because I don't think that we've ever had a complaint made against us for that.
I was going to say, in my history of handling Georgia claims, even though the law, to your point, does not have any teeth on it, we're just of the mindset if it's the law, regardless of the consequences, you should follow it. I mean, it is the law. That's what the law of Georgia says. I have never had an instance where that issue has been challenged.
So forgive me, I'm drawing now on your expertise of dealing with other
Absolutely.
complaints that maybe you said you're familiar with other complaints going through. So if you can just explain to me briefly, some Georgian files a complaint with the insurance commissioner's department. I'm sure they then need to open up an investigation,
Right.
They open
look
a-
into it.
Yes, sir. They
So-
open an investigation, and then we have, I believe it's in Georgia, 7 days. It's either 7 or 10 days to respond in
Okay.
writing to them. They will then seek additional information if they feel it's required. And then they will make a determination as to what to do with the complaint. Sometimes it's calling us and asking us to take action, which oftentimes we will if we feel it's warranted. We try and strive to resolve all the complaints with the Department of Insurance.
And the greatest sanction, as I understand it, for a bad actor, not y'all, I understand, but for a bad actor would be $5,000 if they've just ignored it. The investigation takes place, and then at the end of it, the commissioner says, "Okay, I did the wrong thing, didn't follow the law." The
So-
sanction's $5,000 maximum. Is that
What
right?
I would say the greatest sanction is that the Department of Insurance can revoke our license to do
I see.
business.
All right.
And if there were repeated violations, I would think that that would be something that they would consider.
All right. Thank you.
Sure.
Chairman Fleming.
Chairman, once again, I'm trying to figure out who to ask this question, but on line 81, really starting in line 80, an insurer's failure to comply with subsection A or B of this code section shall give rise to a claim for negligence or bad faith, or may give rise to damages or equitable relief. I'm trying to figure out what equitable relief does in this situation and the purpose for it being there. I don't know if you mean, it's not your bill, I know, but.
Well, the one thing is, it says, it's negligent, it shall be negligence or bad faith and may give rise to damage. So, in my opinion, if an insurer misses any one of these requirements, it opens up the insurance company to bad faith, which I don't think is, I don't know if that's the intent.
Well, equitable relief is an injunction. It
Yes,
is,
sir.
you know,
I guess they could force
latches,
us to
you
get
know,
it
yeah.
and give the information, but again, if we don't have control over getting the information, I'm not sure how that can happen.
I'll save that one for somebody else. Thank you.
Thank you. I appreciate that.
Thank you. Any other questions? All right. Thank y'all for being with us.
Thank you very
Thank
much.
you.
We appreciate it.
I know we had a question raised by Chairman Fleming as to whether this could be applicable to other types of claims, specifically in the medical field. I know we have Stephanie Kendrigan signed up with MAG Mutual. Stephanie, do you want to come up and address that for us?
Good evening. I am Stephanie Kendrigan with MAG Mutual. I'm our Director of Government Affairs. To Chairman Fleming's question earlier, it is our interpretation of this bill that yes, medical malpractice insurance would be included in this, which would obviously be very difficult for us to comply with, especially considering how we operate. I mean, we obviously don't know whether or not whether they were operating their vehicle. We would obviously hope they're not operating their vehicle when they're treating a patient, but we would not have that knowledge. So none of those are really, so if you start looking at the vehicle portions, none of those would be applicable in the med-mal space. The other thing that I would suggest is that if you look down at C, I guess that's line 44, we wouldn't know. It just not really relevant, I guess, in a med-mal case if someone has a house at Lake Lanier and they have a permanent residence as well. So we wouldn't have necessarily their places of residence. That's not information that we would have. The other thing that I would ask is that if you look at lines 50 through 52, a lot of times med-mal cases are very complicated and there could be multiple parties involved, whether it be a hospital, multiple physicians that were involved. I mean, if you've ever, let's take the birth of a baby. There's an anesthesiologist, there's a hospital, there's a doctor, there's all sorts of medical providers that are touching that case. And so it could be very difficult to determine whether or not we had everyone that applied to that case in those 14 days. So I would say that, yes, this does apply to us just because it does open up a code section that applies to any liability insurance. So that was a long way of getting around that, but we would have concerns from that perspective.
And thank you, Stephanie. I don't think that Representative Moptan's situation he was trying to address with his constituents stems from that. I may be wrong, but as we look at possible changes to the measure, I think we can find a way to make clear that we don't want to do anything to harm y'all here. Chairman Fleming.
Thank you, Mr. Chairman. Along those lines, I guess on line 15 it says liability or casualty insurance. Now, I think that would include a fire claim, a house burns down, would it not? Property and casualty. You're shaking your hand, yes. So that's another thing you need to think through, the whole lines of insurance that you're trying not to affect here potentially. For example, like I said, if your house burned down, I don't know that all that would be that relevant. I mean, some of the questions may not be, but most of them may not be. Thank you.
All right. Next, we have Al Cartwright from Georgia Farm Bureau Insurance. Thank you for being with us.
Thank you. I'm the Associate Director of Claims for Georgia Farm Bureau. Georgia Farm Bureau, as many of you are already aware, is headquartered here in the state of Georgia. Since we're a mutual company, we're owned by our policyholders. which are all Georgia residents. We only issue policies to Georgia residents. It's Georgia Farm Bureau's goal to handle all claims promptly and fairly. And our commitment to Superior Claim Service was on full display after Hurricane Michael, when we resolved 8,000 claims in less than 30 days. We do, I just want to echo the concerns that State Farm has raised, in that this bill requires us to swear to facts which we are unable to ascertain. You know, with regard to the time limit, yeah, the time limit's a problem. 14 days makes it doubly difficult to get this information, but as the gentleman from State Farm indicated, we may never be able to get this information. No matter if it's 60 days, 120 days, or 180 days, you're asking us to swear to the purpose of use of the vehicle, whether or not it was used in the course scope of business. When we receive claims, these claims are often submitted to us, not necessarily by our insured, but submitted by a claimant. Sometimes we can't even reach our insureds. They may have moved. We don't have a working telephone number. We send mail. It is returned unanswered. So makes it very difficult to comply ever, but especially within 14 days.
And I'll
So-
ask you the same question. Is there a time inside 14 and 60 that you think would be more manageable?
More manageable for Georgia Farm Bureau to provide information that we know. Information about our policies.
To make a determination of the information you could provide and to get that information to them.
Again, to provide the information that we have, the Georgia Farm Bureau now. Of course, it may be a little more, it may not be as difficult for Georgia Farm Bureau. We're one state company. We're not as large as some of the others. As far as what we can provide, 30 days is probably not generally a problem. But that is, again, only with regard to the policies issued by Georgia Farm Bureau to the insured that we know is involved. We don't know if there are residents in the household who have policies with other companies, or for that matter, residents in that household that have policies through Georgia Farm Bureau. So I am concerned about there being a cause of action for damages for a failure to comply and provide this information when we may never be able to get it.
I think we all want to be mindful and work to make sure that the information we're asking to be provided is something that's that can be obtained. I think anyone's setting anybody up to fail. I think we're all just trying to figure out what can be gathered and easily ascertained, or maybe under the who may be in the best position to help get that. And so as we move forward with this, as we move towards amendments as they're proposed on Thursday, I hope that we can have all parties working together with us to offer some amendments before we send this measure on through. Any questions for Mr. Cartwright? All right, Mr. Cartwright, thank you for being here with us.
One other thing, Mr. Chairman,
Yes, sir.
if I may. Section 2, I don't think anybody's touched on Section 2. We also have concerns with that portion of the bill as well, which creates a private cause of action for a failure by an insurer to comply with, 33634. That bill or that statute pertains to unfair claims practices, and that bill 33634 is it's very subjective. The term reasonable and unreasonable is all throughout that bill. Who determines
All
what's
throughout our
reasonable?
code in general.
Yeah. So yeah, throughout the statute, right? So who determines what's reasonable and what's unreasonable? What is reasonable? What is unreasonable? I'm afraid that any time that there is a dispute and an insured is not happy, or maybe a claimant is not happy with the settlement amount, even if that amount is proper, this gives them a private cause of action to raise the issue that it was not reasonable. So that portion of the bill concerns us as well.
All right, thank you. Thank you for being here. All right. Next, we'll take up Jordan Reed and Dan Snipes from the Georgia Trial Lawyers Association.
Good evening. I'm Dan Snipes. I'm an attorney in Statesboro. I'm currently the president of the Georgia Trial Lawyers Association. The reason that I feel like it's important for us to address this bill is that currently this law provides an obligation that upon receiving a request for a declaration page or policy limits, that the insured of a party who may be liable is required to produce that information. However, if it's not produced within the statutory time of 60 days, there's no consequence. And I think the gentleman from State Farm said that, it's their goal that regardless of the consequence to follow the law. But I think we all know that if laws don't have consequences, there's not everybody who has that same goal of following the law regardless of consequence. And that's the reason that statutes that require action also must have some manner of requiring compliance with that statute. And right now, Georgia law does not have any manner of requiring compliance in the statutory code. Now, what the insurance industry is asking you to do is to require the party that does not receive the information that they're required to receive by statute, and the party that has been harmed at some level, whether personal injury or property damage by the negligence of another, that party then has the further obligation then of going through a bureaucratic process through the Department of Insurance. And without going into a commentary on the Department of Insurance, that's a department that our state has had some difficulty in maintaining consistent leadership with over time. And I just think it's fair to say that's an area that's not the most consumer-friendly part of our state. So what this statute seeks to address is where insurance companies don't do what's required of them by statute, that then there is some kind of obligation. And it goes further, because when insurance companies investigate claims, they're looking to determine not only if their insured is responsible for the claim, but is there other insurance which under Georgia law may have a priority, meaning that it has to pay ahead of that company. So the insurance, the information that's being requested as to other insurance which may be available is something that's done in the normal course of business by insurance companies to determine who has the priority of claims. To address a couple of points that Chairman Fleming made, one of them being that I do believe that the language in lines 17 through 19 of the within 14 days language, within 14 days of receiving by certified or statutory overnight delivery or written request from the claimant or claimant's agent for information. I think that phrase there should be moved up to line 14, prior to making a settlement offer, comma, or contemporaneous with such settlement offer, or within 14 days. So I think the language there that I bracketed from starting on line 17 within to line 19 information, I think there should be an or on line 15 after contemporaneous with such settlement offer. That addresses the concern of if there's a minor property claim and a company wants to resolve it, then as part of making the offer, they just have to disclose statutory required information. It doesn't delay the period of time there. So I think I think just by simply moving that language around, that problem can be addressed.
Let me ask you a question here. I am sympathetic to some of the concerns we've heard in terms of not having information available, but I do understand that a lot of times during this investigation they are asking for the exact kind of information that we're requesting in this bill. And I'm wondering if, for instance, on 53, starting at 53 and 54, on line 54 after the word claim, how it would if we put if such information is known by,
So, Mr. Chairman, if you look at lines 82 to 85, that's current law. If they don't have that information available, they can so state. So these statements that, well, we just couldn't find the information, they already have an out. This is just if they didn't want to provide the information, it'd be an issue.
Okay. All right. Thank you.
That was my second comment, that I think that the language that's already been highlighted in lines 82 through 84 provide as long as you disclose in writing why you're not able to get the information that's required by statute, then it provides a way to comply with the code section, even if you don't have that information available. You just have to take reasonable steps. And essentially the entire civil law is based on the standard, what does a reasonable person do in a set of circumstances. So when the companies talk about, well, who decides what reasonable does, that's what we decide in civil courts every day, what's the standard for a reasonable person and how to act. That's all the comments I had.
Thank you. We'll take some questions. Chairman Estration.
Chairman, Mr. Snipes, what do you say to the concern that was raised that if they want to investigate to maybe get this information that's required by statute, that they can't get it within only 14 days? In other words, is that period of time something that that you think is maybe you could be, or maybe the nature of the investigation might require more than 14 days to get that information? If so, what would that amount of time be?
Well, to answer your question, I think that the first obligation they would have would be to state what they specifically need additional time to look at. And then, because as it relates to the information that's in their control as it relates to their insured, they could comply within 14 days. And then beyond that, I do recognize that may be an area where they need more time. So then if you're looking at a period of 14 plus 30 to approximate 45 days, something like that. So maybe there's a way to tier some of these requests to another time. But I think for where you start out, a lot of circumstances that it is reasonable to require a quick turnaround from, receiving an overnight request.
All right, thank you.
Chairman Fleming.
Thank you, Mr. Chairman. Mr. Snipes, quite often when we try to solve a problem, it's a good idea to get an idea of the scope of the problem.
Yes, sir.
You've mentioned there being nothing in the law as a consequence for failure to follow the current law. Yeah, I mean, you may or may not know this, but I'll ask you, are we talking about a 5% failure rate to comply with the current statute, a 1%, or a 25%? Well, what do you think we're looking at here?
Based on my practice, which is primarily doing this kind of cases over the past 25 years, there are certainly periods of time where it greatly exceeds 5%. Now, my guess would be about 1 in 10, but I also will tell you that I think there appears to be, and this is based on observation, it's not a statistical analysis, but based on my observation, you go through a period of time where companies do a better job of responding, and then they go through periods of time where it's very, very difficult to get responses timely. And it has the effect of making it impossible to allow, whether it's just the claimant or the claimant's lawyer, to properly evaluate, the claim and the case at that point in time. So it is a problem, and it's significant enough that I would say that it's certainly not uncommon, and it's a thing that certainly needs to be addressed.
You also mentioned in your comments the insurance commissioner's office.
Mm-hmm.
And my thought was, would a better solution or an alternative solution possibly be that we put more responsibility on our insurance commissioner to pursue such problems as you're describing now?
Well, unfortunately, I think that creates a separate bureaucratic path that is not directly tied to the claimant, who's the one making the request for information. When you talk about like property damage claims, you're talking about the insured in that circumstance, and the claimant is dealing with his company. So he purchased the policy. He knows what his limits are. He's got a copy of his policy. What this circumstance addresses, and the circumstance that Representative Monahan's constituent brought up, are where the claimant doesn't have access to that type of information. and you're taking somebody who's then been harmed by another person, and you're creating another hurdle that they have to go through. So I believe that because the statute requires certain things to be done, that's the appropriate place to address the failure to do so.
Well, for example, on line 81, we're going to make this a result of failing to comply with the statute fall under a bad faith claim. I mean, is that a better way to enforce compliance with getting information than giving more authority and responsibility to the insurance commissioner?
Well, what it does is it allows the party who's not receiving the information they know to then have a remedy for it. And when a party has information and reasonably has access to information, and it fails to provide something that's required by statute, it's either or. It's either bad faith or it's negligence. And so I think it's appropriate for that language to be used in line 80 and 81.
Mr. Chairman, I believe part of Representative Montame's purpose is to ensure that the average Joe knows what they can get. I would say a lot of people might not be aware that they have the recourse to go to the Department of Insurance. And so this bill, you can use self-help rather than relying on government to get involved on your behalf.
And I wonder if maybe that we ought to include some language notifying that is a remedy as well. I know we've talked about adding some language that deals with, you have a right to seek an attorney. I think maybe we ought to, if that's a large complaint here, maybe we ought to just say that you have a right to notify the insurance commissioner should you feel that this claim is not being handled justly. That's something we'll consider. Any other questions for Mr. Reed or Mr. Snipes?
Thank you.
All right, thank y'all for being with us. All right. Seeing no other individuals signed up to speak to this measure, we'll move to some other measures on the agenda today. We will be taking this measure back up on Thursday, where we will put it to a vote by the committee. We have had some robust discussion today, and we have heard from individuals on both sides. Should any amendments or changes to the bill be offered, again, I would ask for them to be gotten to the chairman no later than an hour before the measure. But we will be taking the measure up, and the chair's intention is to try and move this measure forward. All right. We're going to move now to House Bill 1121. Chairman Efstration, this is your measure, and while you're presenting, I'm going to ask Chairman Fleming to chair for just a short minute, if you don't mind. Thank you. Chairman Efstration.
Thank you, Mr. Chairman. If it's all right, I'll just stay where I am. And if it's all right, Chairman Fleming, if I could have my witnesses go ahead and come forward, if that'd be all right. So Amanda,
Please do.
Farahani, and Dawn Randolph, if you could please come forward. And okay, thank you. All right, so House Bill 1121 is introduced. Georgia currently does not have a cause of action for sexual harassment, so a party who has been the subject of sexual harassment in the workplace has no means by which to seek recovery in state court. Federal lawsuit would be required. And that was actually pointed out to me today by someone who said, there's already an avenue available for these plaintiffs. And so my position is in bringing this bill that we ought to have a cause of action established by state law, and that's the reason that this legislation is before us. So just to briefly go through the bill, Mr. Chairman, so we have some definitions that we initially provide here. I will note that if there are, I think the desire was to have a very broad application for the types of potential organizations or corporations that would be captured under employer, but we can discuss that certainly going forward. Want to make sure that we have the right type of potential, that language is correct. For sexual harassment, you'll notice on lines 22 through 25. That language was put together with an attempt also to cover you'll see in 24 to 25, if an employer fails to take corrective action, that there be the means by which an employer could take corrective action to avoid liability with respect to this claim. So the cause of action is then begins in line 32. That makes clear that that if sexual harassment is perpetrated against the claimant, and the claimant doesn't have to be, as you'll notice from the definition, a paid employee. So if there's, say, an unpaid intern or somebody else in the workplace who is working in that area, they would potentially have a claim. And then we have some very specific and I think rigorous restrictions that are put in place for what would need to occur in order for a claim to actually arise. And this is against the individuals involved. But with respect to the employer will be covered in B, which is lines 47 to 49. And I will just note, I think that's actually the proper place to put the corrective action component. So we'll have time, it sounds like, to work on that if this bill is just being heard today. And so I'll look forward to input in that regard. We have a statute of limitations that's provided in 50 to 54 of 1 year. In lines 55 to 63, we have defenses that include what you'll see in lines 58. Defenses would include what to a reasonable person would be considered merely tactless, boorish, inconsiderate, overfamiliar, or otherwise impolite. And that's viewed in the totality of the circumstances. And then also in line 63, consensual contact between coworkers would be a defense. And then finally in line 64 to 70, it specifies the damages available. And 64 to 67, and then 68 would just makes clear that would not prevent any other action. So, Mr. Chairman, I'm happy to answer any questions, and maybe if I could, I'll just turn it over to Amanda first, who can maybe discuss the thinking that went into the bill and just any potential areas where you think it might be helpful for the committee members to be aware of due to your practice in this area. Thank you.
Thank you for being with us.
Thank you to Chairman Kelly, members of the committee, Representative Efstration. I'm very appreciative of you bringing this bill forward, especially in such a busy week. My name is Amanda Farahani. I live in Buckhead. I work for Barrett and Farahani, and I'm the chair of the Georgia Coalition for Safety at Work. Thank you for the opportunity to submit this testimony. House Bill 1121 is an important step forward in the effort to prevent and respond to the serious issue of sexual harassment and to improve the Georgia workplaces. So sexual harassment occurs in nearly every type of company and at every level of employment. And the costs to businesses are very high because of employee turnover, lower productivity, increased absenteeism. Sexual harassment has been identified as one of the most damaging barriers to career success for women, who make up over 80% of the complaints of sexual harassment. And sexual harassment affects women at every level of employment, holding women back, threatening their safety, health, and economic opportunities. 90% of the voters who've been polled on this issue say that they want to see sexual harassment legislation, and that they want to see protection from sexual harassment, and they see sexual harassment as a very serious problem in the workforce. Studies have shown that between 25% to 85% of women have been sexually harassed at some point in their careers. The reason that Georgia needs House Bill 1129 is because Georgia citizens who are sexually harassed have little to no remedies, even for egregious acts of sexual harassment, like someone groping the private parts of a woman. Georgia has no state laws that prohibit sexual harassment, and it's only one of the 3 states in the entire country that does not have any protection for sexual harassment. The Equal Employment Opportunity Commission, the EEOC, is the federal agency that handles employment cases, and they only investigate and resolve less than 2% of the claims that come to them for any kind of employment discrimination. After study has shown that the federal court in Georgia, the federal law that people were telling you, Representative, that were there to protect employees, dismisses all but a few cases that ever reach the courtroom. Most important to this bill, in sexual harassment cases, those cases that are not settled out of court, in 90% of those cases, the federal court is dismissing the cases. What that means is there is no remedy here for Georgia citizens. You might have heard or seen the the Atlanta Journal-Constitution, who's written several stories about that, the most recent being odds stacked against victims of sexual harassment in Georgia, citing to the different studies that have shown that Georgia citizens don't have rights for sexual harassment. And under current Georgia law, experts have opined that employers don't know how or what to do to either prevent harassment or even what harassment is, and that that's having a recursive effect back into our workplaces. So this bill is going to help Georgia citizens with the rights that they should already have under federal law but don't. But it's also going to protect Georgia whistleblowers who come forward and complain about it. But most importantly, this bill also does 5 important things that the federal law doesn't do at all. The first is that this bill holds harassers individually liable for their sexual harassment. Under Title VII, the federal law that protects employees, only companies and not the individual harassers themselves may be held liable. And so as a result, what that means is that if an employer chooses not to take any action against the harasser, then that harasser is never held accountable for their wrongdoing. So what this bill is going to do is provide a way to hold those wrongdoers accountable for their own actions. Second, this bill also protects a set of workers that desperately need this and are not covered under the federal law. So, for example, interns, students who work at companies, and importantly, independent contractors, which we're seeing more and more of under the gig economy, are not covered under federal law. And this law would provide those Georgia citizens with a remedy. Third, this bill provides for more time for the employer to resolve the situation. In Georgia, an employee has to go to the EEOC within 180 days of the sexual harassment. What that means is they are required to go and file a federal charge and have the federal government get involved into our Georgia businesses before an employer even has an opportunity to do anything. This expanded amount of time to allow them to do something and to allow the employer to come forward and have a remedy means that employers are going to have the federal government out of their business and have an opportunity to resolve it themselves. Fourth, this takes the federal government, the EEOC, out of employers' businesses, and they put this important issue back into Georgia businesses' hands. And fifth, this bill will clarify what is and is not permissible sexual harassment in Georgia workplaces. The language of this bill is based off the language that was in the General Assembly's Sexual Harassment Handbook. So it's the same ones that you all are being required to abide with. So we should have all Georgia citizens also required to abide by it. This law is not prohibiting offhand comments, asking someone out for a date, or things that are not serious. That's not the problem that we're addressing here in Georgia. The bill solves the status of the law in Georgia, where what Georgia considers a crime, groping a woman's private parts, is not sexual harassment because the federal courts say that that is not severe enough. I'll be glad to answer any questions, and I ask for you to favorably move this bill forward. Thank you.
Chairman Fleming.
Thank you, Mr. Chairman. Counselor, thank you for being here today.
Thank
Is
you.
this your exclusive area of practice?
I do employment law, yes.
Okay.
So I primarily focus on sexual harassment cases, but I do employment law as a whole. So I represent employees at all different types of employment issues.
Employees.
Employees.
Okay.
Yes.
You mentioned that this would take this issue out of the hands of the federal government.
Yes.
By passing a state law, are we going to preempt EEOC claims?
No, of course, people still have the right to go to the
Okay.
EEOC.
I didn't know if there's some provision if a state takes a.
No, it
Okay.
doesn't preempt it, but now it's a requirement before you can proceed federally to get the federal government involved. And so without having that requirement, people wouldn't have to go to the EEOC and would be unlikely to do so.
And you may or may not know this. This may be for Chairman Efstration, but my question was this language that we have here, was it taken from another state, by example?
That but part of this was language that we worked on. We do have a substitute bill that is more in line with some other states that are out there, but it's language that we've been working on with the National Women's Law Center and the House Representatives. And GTLA, I believe, also.
That's right. We put together the bill with sources from several different, several sources. Yeah.
So, do you have a copy of the bill?
I do.
Okay. Line 34. A claimant shall, well, starting in line 33, a claimant shall have a right of action for sexual harassment against a coworker or supervisor who, as viewed by a reasonable person. So in other words, is that there so that if I can show that I thought that was my supervisor, I have a claim? What is that language supposed to do right
I
there?
think the reasonable person is related to the sexual harassment, so that the
Okay.
reasonable person would view something to be sexual harassment, so that someone who might be more inclined to call someone out wouldn't necessarily be held responsible. That the harasser would not be responsible.
It's a reasonableness standard
It's a reasonable standard
doesn't
for
have
harassment.
for everything that follows after it. Okay.
Yeah.
All right. And then also on line 48, this code section a claim shall exist, and this code section against the employer when the employer knew, and then the next phrase, or should have known.
Mm-hmm.
That or should have known, that's what I want to ask you about. I know, I understand knew.
Sure.
But I want to understand should have known.
So there are circumstances in where you have open and obvious type of harassment that's going on in the workplace, and employers say, well, we didn't know about it. But because all the employees know about it, the person had a prior history of doing this, there had been complaints made along the way to other people, then that's the type of situation where they should have known about it. There's a large body of law around the should have known and what an employer's obligation is under sexual harassment. And this mirrors the negligence standards that's already in place for the types of employment claims that are available in the state court.
Like what?
Intentional infliction of emotional distress. And under that, in order for the employer to be responsible, they had to know or should have known about it.
Okay, thank you.
Representative Oliver.
You said, I was interested that there were only 3 states that do not have a sexual harassment statute.
Correct.
In terms of defining the employer by number of employees, is that fairly consistent with other state statutes? Here you suggested 4. I just wonder what the range, because the federal statute is more than that, isn't it?
Federal statute is 15. States are anywhere from 1 to 4 for that. So 4 is the high end of what we've seen in other state statutes.
You mentioned intentional infliction. I was embarrassed to say to myself that I didn't know that there wasn't a tort for sexual harassment. So you're bringing these cases, but you're bringing them under intentional emotional stress and what other claims?
So the types of claims are the federal law for Title VII and the intentional infliction of emotional distress. Intentional infliction of emotional distress requires even more than the federal law does, and it also requires that an employee go and get medical attention, which most of the time people who are sexually harassed and have lost their job have also lost insurance and can't also get medical attention. So in order to prove the emotional distress element.
Thank you for your help with this. Very helpful.
Thank you.
All right. Any other questions? All right. We also have Ling Ling Chansey signed up to speak. Ms. Chansey?
Yes. Good evening. My name is Ling Ling Chansey. I'm the National Executive Director of NIDA 5 National Association of Working Women. We have 4 chapters across the country: California, Wisconsin, Colorado, and right here in Georgia. I'm pleased to speak on behalf of our organization in support of HB 1121. This is a bill that is important in its first step in preventing and combating workplace sexual harassment in Georgia. NIDA 5 National Association of Working Women is a national membership organization dedicated to achieving justice for working women and their families. We have been hearing from women about the devastating and widespread incidences of sexual harassment since our founding in 1974. And the Georgia chapter was founded in 1982. We are proud of our role in the movement to win changes in law, social, and workplace expectations, and to have supported the increasing willingness of women to step forward and challenge workplace harassment over the last 45 years. Sexual harassment to us is an abuse of power used to exert control over individuals with less workplace power or status. It reinforces gender inequality. It's a huge issue for women in low-wage jobs, women of color, immigrants, LGBTQ people, formerly incarcerated workers, etc. It occurs at all levels and all types of businesses. But it's the greatest impact is on those who already are most directly impacted by inequalities and injustices and have fewer available resources to support. However, in Georgia, there is currently no law making sexual harassment illegal or preventable in companies with less than 15 employees. Title VII of Civil Rights Act of 1964, which has expanded to include sexual harassment as a form of gender discrimination through court challenges in the 1980s and 90s, applies to employees of 15 or more only worker. This leaves a huge segment of our state workforce with no protection. In addition to providing a legal remedy for sexual harassment for those employed in companies with more than four but less than 16 workers, this bill provides additional legal recourse for people who are experiencing sexual harassment and are currently covered by only by federal law. HB 1121 extends the statute of limitations from the 180 days provided under the federal law to 1 year. It also provides provides a private right of action, allowing those who have experienced sexual harassment to sue their harasser and the employer if they fail to remedy the situation in state court. 9 to 5 staff have answered hundreds and thousands of calls from Georgia women about sexual harassment through our job survival helpline. We've trained hundreds of women and men in community workshop, corporate and nonprofits training sessions, and college classes about steps to take at work through the legal system and to stop and prevent this. 9 to 5 supports HB 1121 as an important step in recognizing that all workers deserve legal protection to allow them to combat and prevent sexual harassment in the workplace. Thank you.
All right. Thank you so much. Any questions for Ms. Chancey? All right. Thank y'all for being here with us today. Thank y'all. Chairman Administration, you have anything you'd like to add to close?
Mr. Chairman, I really appreciate the hearing today, the testimony we've heard. We have an opportunity to send a strong message that sexual harassment will not be tolerated, that a cause of action in Georgia law will allow for victims of sexual harassment to have recourse in Georgia's courts. And so I really am proud to carry 1121, and I want to thank our outstanding witnesses here today. And thank you, Mr. Chairman.
Thank you. All right. We're going to move back to the next measure. We're going to go to House Bill 1116. Representative Gullett. If you'll hit your button, you stay right there. All right. Talk to us about House Bill 1116.
Thank you, Mr. Chairman. House Bill 1116 deals with uninsured and underinsured motorist insurance coverage. Underinsured and uninsured coverage applies when a person at fault has no insurance or does not have enough insurance to cover the claim. It's a common form of insurance and a huge source of profit in the insurance industry. This legislation here, a very similar piece of legislation, HB 303, was passed by Representative Hightower, not Judge Hightower, back in 2015. It passed the House with a 153-14 vote at that time. But what this bill does is it talks about negligence and bad faith. So bad faith is when an insurer delays payment, or otherwise fails to settle a claim, such as by lowballing with good cause or without good cause based on terms of the policy and the facts surrounding the claim. Today's current law, when you're insured and you have an accident, you make a claim for that loss. If your insurer negligently denies or fails to settle the claim, you have no effective remedy. If your insurer in bad faith denies or fails to settle the claim, then you have limited remedy. The insurer, as proven as a second lawsuit against the insurance company, is liable for, at most, 25% of those limits, even if you suffered more damages and possibly related attorney's fees. Under current law, There's no remedy for negligence, like I said. Unlike other negligent people or companies, the insurance industry is immune for their own negligence to their own customers. The bad faith penalty in real life has no teeth. Insurance companies are free to act in bad faith, knowing the insured will not take them to court because of the expense. And I believe that there were some, there's actually news coverage here recently of WSB. Says, are you in good hands? Not if you get hit by someone, the Allstate victims say. Real world example of this. So you have your minimum insurance required by law, which is $25.50 coverage. That's $25,000 max per person, $50,000 total. If more than one person is in the car, obviously there's exceptions because people buy higher limits. If you get hit by a drunk driver and are hospitalized with brain injuries and broken arm for 20 days, say your medical bills exceed $100,000, the at-fault drunk driver is uninsured or only has the minimum policy. The underinsured motorist coverage of your insurance would then apply. If the company offers you $15,000 offer, you already have over $100,000 in injuries, $15,000 offer, because they know the maximum penalty for bad faith failure to settle the claim is $6,250. The insurance company knows it's not worth the expense and time, for them to sue for bad faith. And so you really only get your money back for attorney's fees. So insurance companies routinely deny uninsured and underinsured claims, knowing there's no real consequence. So what this bill does is it actually removes that cap. I mean, it removes the 25% as far as what you can get back from an uninsured or underinsured claim there. This bill addresses bad faith practices by removing the penalty cap of 25% of the insured's recovery, since most states allow an uncapped recovery. The way the bad faith denial of claims is not a minor cost of doing business, and that's on line 14 through 19. Negligence is also included, giving the robust Georgia case law that bad faith is often negligence in failing to timely pay claims. That's line 13 and line 20. And the bill would also require that the insured's demand for payment be in writing. That's in line 12. Other states, what do? Georgia is the only state that uniquely treats underinsured and uninsured bad faith insurance claims differently from other types of bad insurance claims. And I just wanted to talk just a quick second about negligence and what negligence is versus what bad faith is. I think we all know what bad faith is. You did something intentionally to harm one. Negligence, though, it's like running a red light and messing up your job. You didn't mean to do it, but you did it, and it caused harm to someone. And just because you didn't mean to do it doesn't mean that the harm goes away. So that's why we include negligence here as well. I'm happy to answer any questions if I can help.
Thank you, Representative Gullett, and thank you for giving us some of the backstory. I remember when then Representative Hightower, my seatmate, had a measure that he was extremely passionate about. Now Judge Hightower, and really came with this as a consumer protection measure.
Right.
Because isn't it true that while we do mandate buying liability insurance to cover individuals who you cause harm to, that we're not mandated in any way to purchase?
Yeah, that's actually in my notes. We require you to buy insurance, but we don't necessarily require the insurance company to protect you.
And so and when we talk about those are individuals who have decided to purchase insurance above what the law mandates to help try and shield themselves from bad actors to begin with.
That's right. You have insurance. You expect the other person has insurance, but when they don't, or they don't have enough insurance to cover you, that's right.
You said Georgia is the only state that treats bad faith claims for uninsured motorist coverage different from liability coverage bad faith?
That's my understanding, yes.
Okay. I remember Judge Hightower's, and he was here earlier this week. Too bad we don't have him around. Let him see the next step of what's going on here. But I remember his measure removed the 25% cap, but I think he limited it to the policy limits that were purchased. Can you speak a little bit to the decision you made to allow it to go above the excess of the policy limits?
Yeah, I mean, I think it really depends on when you have insurance and you believe that you're going to be covered to that insurance. And if you're the people you're paying for this insurance, and when they act in bad faith or they negligently don't help you in the proper role, it doesn't matter.
You buy insurance because you expect it to be there when
And
you
you
need it.
expect your own to take care of you. You sometimes understand when the other side's fighting you a little bit but you have your insurance. This is your folks. You're their client.
Be on your side.
That's right. You expect them to take care of you, and when they don't, that really it's even more egregious in my mind that you're paying for this help, and they're not coming to the table to be by your side. That's what you're paying for.
And I know you weren't here then. Do you remember how then Representative Hightower's bill, how it moved through the House?
Through the committee process, is that what you're asking?
No, I believe it passed pretty overwhelmingly out of the House.
It did, yeah. It passed, and I had that number, 153 to 14. And there was a representative from Athens, I think, who went. I think a lot of people. There was some movement there to try to stop it, and I think it actually didn't work. I think people understand, hey, I'm paying for this coverage. I expect to have this coverage, and when they negligently or in bad faith don't give you that, then there's a problem, and it overwhelmingly passed because of that, I believe.
Thank you so much.
Thank
Any
you.
questions for Representative Gullett? Chairman Fleming.
Representative Gullett, I'll direct this towards you or the chairman because he seems to be knowledgeable of it also. But I think I have a concept of what bad faith is. But what I'm trying to figure out is how does one negligently fail to settle a claim? And I guess I would start by asking this. And once again, I'm trying to form the question, and I don't know if I'm going to form it correctly. Maybe you can help me out here. But let's say that 25 grand is offered, but later on a jury decides you should have gotten 100 in some form or fashion. Is that negligence?
So I'm not an attorney.
That's why I brought the chairman
Sure.
in here
So-
for you, just in case he wants to try to give it a shot.
I mean, he's welcome to. He's welcome to give it a shot.
Or we can wait on witnesses, whatever the chairman wants.
I would, as I've always been taught, negligence, it's duty, breach, causation, damages. And I would say that as we know, bad faith claims are a separate cause of action outside of the original suit against the individual who created the tort. And so I would believe that it would just give you the opportunity to allege negligence along with bad faith. And of course, there would be different elements that would have to be proven in a court of law from the negligence versus the bad faith. They have certainly different standards, but it would be a separate claim that would have to then be brought after after an award in excess of that would been brought. So, and of course, the plaintiff at that time would have to prove the elements of duty, breach, causation, and damages as determined by as a jury. Representative Oliver.
I'm not remembering well enough Judge Hightower's bill. I remember how hard he worked on it. I remember how I remember specifically being so appreciative and admiring the effort. It took the 25% cap off everything over $25,000. Is that what it did?
I believe that's correct.
And this is closing the gap. I'm sitting here thinking about negligence. Here's what is an example of negligence. A negligence would be when the insurance agent did no investigation. He or she didn't make any effort. I'm making this up, but I'm trying to think through what would be the jury. They offered $25,000. The jury returned $100,000 because the medical claims, actual bills, were $50,000. It would be negligent of the insurance adjuster to not even know what the amount in controversy was. What are some other examples of negligence that would help me? And I ask the chairman or Mr. or Mr. Evstration.
I mean, I'm no attorney, so, but I believe that that's actually when you're just pushing your client along. So your person is needing help. And
You're doing
just,
no work.
That's right.
To understand the claim.
Paperwork's
That's
kind of piling up
negligent.
on them, and you know.
So the plaintiff would
I
have
mean-
to prove that the adjuster did absolutely nothing that would be with any kind of reasonable job duty. That's what I'm thinking. Is that what?
I mean, I think we're probably looking at a couple levels. You know, you get bad faith, which is certainly one threshold. Negligence would be something a little lesser than that. Certainly, you know, bad faith would be almost the intentional, you know, disregard. You know, I mean, I think you can. You know, these obviously are very factual base inquiries. You know, is $100,000 of medical bills that results in a $25,000 bad faith? In my mind, every day it is. But obviously, those are very factual inquiries.
But it wouldn't be just the jury awarding more.
That's right. It'd be the actions that they took leading up to their determination based on how much to offer.
And maybe as we go forward, because I understand we're having these bills again this week.
Yes.
This week being
Thursday.
Maybe I can do some more work for myself to learn what are other examples of negligence other than what I'm kind of speculating about right now.
Sure, and I'm happy to meet you offline. We can work through that too.
Chairman Fleming.
The next question I was thinking about is on line 17. The phrase that is underlined there, it is being added. In any damages caused by a violation of a law of this state. What is the effect and purpose of that language?
Unlimited amount of excess policies. And any damages caused by violation. So if you were negligent and whatever damages caused by a violation of law in the state. So I guess if you did something in addition to bad faith.
Well, in other words, if you couldn't make your mortgage payments because you didn't get a good settlement and you lost your house, would that be a damage caused by a violation of this law?
I don't know.
Maybe somebody else can comment on that as we go through this process.
All right. No other questions for the presenter of the bill. We have several individuals, witnesses signed up to speak. So if I'll go on and bring up Todd and Mark from State Farm again.
Mr. Chairman, Mr. Bevel had to leave.
Oh.
His job, so it's just me.
All right.
Mr. Chairman, thank you again. Mark Tilkin, the Corporate Law Department of State Farm Insurance Company. First, I think I need to maybe defend the insurance industry a little bit. I know there's been a lot of talk about how, from the talk, it appears that insurance companies intentionally don't pay because they don't think there's any penalty. I can only speak for State Farm. That is not true in my company. Again, we handle about 1,000 claims a day just for Georgia. Can I guarantee every single claim is handled perfectly? I can't. We are human beings. We make mistakes. We try to fix our mistakes. I can tell you that we are trained to do the right thing, and I believe we do the right thing. So I just want to make sure that that is clear. I feel a little bit,
And I'll jump in and say I don't think anyone's looking at trying to take any measure aimed at people that are acting appropriately, and I don't think anyone who is acting appropriately should have any reason to fear maybe some of the provisions in this measure.
I would respectfully disagree with you, because I think you could do everything perfect, and this bill will have a drastic impact on the way we handle claims, the way claims are handled throughout the state of Georgia. So let me talk about uninsured motorists for a second. Uninsured motorist is different than a third-party liability claim, okay? So we have, it's a first-party coverage, and it's a contract. So you come into State Farm, your State Farm agent, and you decide what level you want your policy to be, and if you want to purchase uninsured motorist coverage, and you agree, you know what? I would like to buy $50,000 worth of uninsured motorist coverage to protect me and my family in case a driver who is not insured, who is underinsured, strikes me. And you agree with your insurance carrier that you will purchase that amount of coverage, and a premium is then charged for that amount of coverage. That's a contract. If you are in an accident and there is a uninsured motorist claim, and you feel that that claim was not settled or offer was not made to your satisfaction, that's a breach of contract. It is different than a third-party liability claim where we indemnify our insured, and our insured then is sued. There's a judgment in excess of the policy limits, and something we could have done may have prevented that excess judgment. In that situation, we are bound to pay the amount of the judgment, that the ultimate judgment, right? That if we're sued and found to be in bad faith, to protect that insured. In the uninsured motorist case, it's a contractual obligation. We are obligated to pay up to the uninsured motorist policy limit, which is whatever the policy limit is. And that is what the parties have contracted to. The legislature has made a determination already that if there is bad faith in the handling of that claim, there should be a penalty. And they've made the determination that the penalty should be 25% plus the insured's attorney's fees. I believe the attorney's fees is already included in the original law, in the current law. So a couple things. I believe that penalty is appropriate. 25% is a significant amount of money, especially if you're going up higher in your policy limits. I happen to have a $250,000, $500,000 policy on 3 vehicles and $1 million umbrella. 25% of my policy limits, when you stack those together, is a significant amount of money. So I'm testifying that I believe the current law is appropriate, and I have not heard, and I've talked to my defense attorneys that we deal with, there doesn't seem to be a lot of litigation or complaints about the amount of uninsured motorists. I could be wrong, and to be honest with you, I haven't stepped foot in a courtroom for about 15 years, and I don't do this regularly anymore. So again, there is a penalty. 25% is not an insignificant penalty. So let's talk about what this bill would do. Number one, it opens up not only bad faith, but negligence. So if somebody makes a mistake on a claim and somehow a verdict is entered, let's say they go to trial against State Farm and there's a $50,000 policy and the jury comes back $1 million. And a claim rep missed something or made a mistake and was negligent. Well, State Farm is now obligated to pay the full amount of the judgment, $1 million, for a mistake. In a breach of contract case, number one, I've never heard of negligent breaching a contract. You usually, there has to be some kind of intent. I just never heard of that. And we couple that with some of the issues that are currently going on, and I know this committee hasn't addressed it, but other committees have, where some attorneys, I'm trying to find the best way to say this, but quite frankly, try to set up insurance companies to make mistakes. And that happens. And we get the 27-page demand letter with 50 footnotes written in a font that almost is indecipherable, and somebody in the claims department has to go through that letter and make a determination as to how to comply. And in my opinion, some of those letters are geared towards almost forcing the insurance company to make a mistake so that it opens up the policy limits. If we have a law in the state of Georgia that says if you, insurance company, are negligent or you commit bad faith, and if you do that, the penalty is not going to be a percent of the recovery as it currently is now, but whatever the jury awards. There will be the threat of bad faith litigation in every single uninsured motorist case. And you say, how does that impact me? Well, number one, I didn't think I was testifying on this bill until this afternoon. But as I think this through, as an insurance company, if we have the threat of opening up policy limits on a contractual coverage like uninsured motorist, sometimes it's hard to take the risk that, when you made an offer or you think you did everything right, but maybe a judge or jury might disagree with that, the fact that the ultimate verdict would be what you would have to pay on a first-party contract action where you collected a premium for what the policy limit was, I can't imagine how claims will deal with that. And, I can envision, especially some smaller companies who can't afford to pay some of these outrageous judgments, will just start paying policy limits on every case, no matter what. And that's not good for anybody in the state of Georgia, because it makes claim handling very difficult. If companies feel that to protect themselves, they just have to pay the policy limit, maybe you'll like that. I don't know if the people that pay the auto insurance premiums will like that. And I never try to combine the price of insurance with tort reform or some of these, but I don't see how this is a sustainable way to do business. And when we couple it with the 1101, where we again will be threatened with extra contractual damages if we don't provide information that we maybe not be able to get within 14 days or whatever the bill ends up being if it's amended, we are creating a claims environment in the state of Georgia that, in my opinion, will be almost the worst in the country. And I don't think that's where Georgia wants to be. So I strongly oppose this measure.
Thank you. Chairman Fleming.
Thank you, Mr. Chairman. I do remember when now Judge Hightower, Dusty Hightower, had that bill a few years back, and I remember what I told him. I said, the strength of your argument to change this law are the small policy limits. When there's a $25,000 policy limit, and correct me if I'm wrong on this, I'm trying to work from memory because I don't do this that often. But when there's a $25,000 policy limit and the penalty is 25%, that's only what, how much is that?
$6,250.
Yeah, what he said. So
I'm gonna have to believe you because I'm not good at math.
That's a lot of money, and particularly from certain people's perspective.
Plus attorney's fees.
Yeah, plus attorney's fees. But if you want to solve that problem, I told him make it $100,000 or 25%, whichever is less, I guess. Well, no, actually, you have to word that differently. You have basically a floor that you wouldn't go below of $100,000. So you and I probably will disagree whether or not $6,000 in attorney's fees is a lot of money on this issue, because you'll want it to stay at the 25%. And I think the solution to this is to make it this amount or 25% to get that number up.
Yeah, when you say this amount, what amount are you referring to?
In other words, the penalty would be $100,000 or 25%, but not greater than $100,000. I guess, or not less than $100,000. What the penalty would be.
If
so
25% of the policies were in excess of $100,000, then it would be the 25%.
I think you're. It may not be a while, and I've been wrong many times, but I think you have a weaker argument here with the smaller policy claims. And that's where the weakness of the law is. And that's what's going to be addressed eventually, I suspect. And sometimes when y'all come forward with a proposed solution with the industry, you get better resolutions than you do by not doing anything.
May I respond to?
Please,
that?
please.
Thank you. We talk about the smaller policies, but that is a policy that a person agreed to buy to protect themselves.
Yes.
So the expectation of that person, if they got into an accident with an uninsured motorist, is that they would get no more than $25,000 or $25,000.
Correct.
I decided to protect myself and my family that I would get a lot more insurance. I'm really not. But I made that decision because I tried cases and I see what, I see what can happen, right? And I'm not going to rely on somebody driving in the state of Georgia to pay me. I made a decision that it's worth it for me to protect myself and my family to pay more money for that coverage. So my expectation is that if I get in an accident, I will have that coverage.
Yep.
So a person that has an expectation that they will pay for a $25,000 policy and get no more than $25,000, well, maybe 25% of that $25,000 is a lot in that situation. It may not be a lot. $6,000 may not be a lot in my situation if I have almost $2 million in coverage. But 25% of $2 million sure would.
I agree.
So again, you have to look at what that person's intent was when they bought the policy, how much that policy cost them, and their expectation was if something bad happens, I'm getting $25,000. Not whatever
And-
the amount of the award is.
And the last thing, Mr. Chairman, exactly, you're correct. And when you don't meet a proper expectations, you run into a bad faith claim, potentially.
And there's a
That's
penalty
what-
for that.
It is.
That's
And
correct.
what we're not discussing whether or not someone should get more than 25 grand. We're discussing if they got the 25 grand they should have got, and thus not triggering a bad faith claim. So the question is, when you enter into the area of bad faith, not were you expecting to get more than 25 grand, but how and when you were expecting to get it, and what should the penalty be when bad faith does occur. And when you have only a penalty of bad faith of $6,000 or something, I would say that there's you opening the door for the accusation that that's low. And if you would come forward with a higher penalty on the smaller claims, then you would take away a lot of the vitriol that goes with the reason why Judge Hightower got 130-some votes on the floor of the House.
No, I totally understand that.
Thank you.
Absolutely.
And let me jump back in here, and Chairman Efstration, I'll be right over to you. How many states does State Farm operate in?
49.
And is what Representative Gullett said correct, that Georgia's the only state that treats bad faith claims different from bad faith liability claims? Could you speak to that?
I don't know, but I'm not sure that's true. So I practiced in Maryland. Maryland didn't have bad faith. When I practiced there was no bad faith. When Maryland changed and got bad faith, it was all administrative. So if there was bad faith, then the Department of Insurance had a unit that investigated it and made a determination whether there was bad faith and assessed the penalty to the insurer if there was. I will tell you there was no profit in it for anybody, and it is a different environment in Maryland than it is in Georgia.
If we were to find out that in a large number of the states that State Farm operates, that the bad faith claims for liability are treated the same as bad faith for would you have as bad of a problem if we treat them the exact same in Georgia as well?
Well, I'd like to find out what the information is, and I'll try to find out.
Okay, thank you. Chairman Efstration.
Thank you, Mr. Chairman, and maybe you can help to educate me on this. It's my understanding that for third-party claims that the 25% cap isn't in place. Is that correct?
Well, a claim would always be a first party.
Okay.
claim.
So would there be any circumstance where the 25% cap would not be in place?
In an uninsured
Yes,
motorist,
sir.
I don't think so. But
Okay.
again, I'm not holding myself out as an expert in that.
guess as I really understand this issue as you're presenting it, it is the freedom to contract is very important. The terms with which that contract are entered into are important. But then there's statutory guidance as to as to limiting potential recovery.
Sure.
That's just in the law.
That's correct.
And so I guess my question is if we're really embracing the freedom to contract, not talking about the other aspects of this bill, but how would you feel about simply removing that 25% cap and not incorporating in, say, the negligence and things like that, so that you could just include it in your contract?
I'm
In your
not sure I'm
policy.
following you. So the penalty would be baked into the policy instead of by statute?
If the parties decided to do that, I guess, is there any, in other words, it just seems to me, and it seems to me inconsistent, and you can explain to me if my thinking, if I'm off on this, but if it's really about parties to a contract, right, and the terms with what the amount of coverage and all that is discussed, then is it not inconsistent to then rely upon a statutory cap that predetermines potential exposure?
Well, that's what we have already.
Yeah, and this bill seeks to take that away.
That's correct.
Okay.
Yeah, I don't think if we changed our contract to, say, include a 25% cap, I don't think we would be in compliance with the law, if the law is changed to the current version of 1116.
All right. I don't see any other questions for you. Thank you for being with us.
Thank you so much.
All right. Moving on to Jordan Reed and Dan Snipes from GTLA.
I'm Dan Snipes still. We all haven't heard a little bit on these things today. I want to just try to address some specific things. First of all, I think it's important to remember that the way the Georgia Code 33711 defines uninsured, it really relates to a handful of situations. One's when the party who's at fault has no insurance. But then the second definition is when the at-fault party doesn't have enough liability coverage to fully compensate you for your claim there. When there was some discussion about what's the difference between negligent and bad faith, I think it's important to understand that in order for the penalty provisions that we're talking about to apply, it's not just because there's an excess verdict. There has to be either negligence, and I would hold out that negligence is a circumstance where you send a demand and it's lost, it's not responded to, for some other reason you just don't get a response, or it's the kind of circumstances been mentioned where there's just a failure to investigate, a failure to properly do the things that are required by duty, which Chairman Kelly mentioned. Bad faith falls into the circumstance where there's a driver who's at fault, who has no insurance. He causes harm. Someone has $100,000 in medical bills plus some kind of permanent injury, and there's a policy that provides $25,000, and it's just not offered, even though there's overwhelming evidence of fault, overwhelming evidence of damages that exceed the available limits. And I know we want to talk about circumstances where companies always try to do the best things, but I have had a claims adjuster tell me that a minority death in a rural county wasn't worth $25,000, where the other party was clearly at fault. So there are circumstances where there is just actual, I guess what I would call shocking and, quite frankly, offensive bad faith that occur. And the problem is, and where this goes to in this circumstance, and I think Chairman Fleming has correctly identified where the problem is, when the penalty is only 25% of a low limit like $25,000, there's not an incentive to pay $25,000. And in fact, I think there's been some investigation done into not State Farm, into Allstate, where they've actually had a business practice of, over the long term, we're better off not to offer the limits on small policies because the penalty isn't strong enough, and not enough parties are going to seek to get it. Because if you've got a claim that's worth an $25,000 and you're only offered 20, are you better off to take the 20 and go on about your business and let somebody short you to $5,000? Because the penalty doesn't justify going forward. And that's what the current statute does. It creates no incentive on carriers to fairly handle these claims. Now, if they're handling them fairly and they're doing the things they're supposed to and a jury just disagrees with them, that's not negligence and that's not bad faith. But there are circumstances where there's negligence and bad faith, and right now the current penal provision is just insufficient. Chairman Fleming asked a question, I think, about the damages part of it. And what the purpose of the damage section is to make line 18 is to make the injured party whole again, to return them to where they were prior to whatever negligent act caused them to be harmed. And that's what we're talking about. There was some talk also about the expectation about when you buy you only contract for $25,000 with coverage. The expectation, though, is if you have a claim that is a claim for however it gets there, your expectation is you'll be treated fairly and that you'll be paid, and unless it's negligence or bad faith, then your expectation should be met. The way a company meets that expectation is by tendering the limits. If they tender the limits, they're never in a circumstance where they're negligent or in bad faith. They fulfill their obligation if they handle it properly. I think it's important to note that, when you talk about other states, I don't know about every state, but I know Florida treats liability and bad faith the same. And the party, if an insurer does not fairly resolve a claim and they're found to be in bad faith, then the injured party gets to recover their entirety of their damages, regardless of the liability limit or regardless of the limit. So Florida's a state where companies write policies every day. And that's kind of the threat that's been made here, is that if we don't have this protection, no companies want to write coverage in Georgia, but companies write coverage in surrounding states every day that don't have the 25% cap. Those were my comments.
Any questions for Mr. Snipes? Chairman Fleming.
Mr. Snipes, negligently is what I want to focus on here.
Okay.
I'm all about bad faith because that's like an intent. This is a penalty, and we want to penalize people who do things intentionally. We don't always want to penalize people who make a mistake. And what bothers me about opening it up so wide to negligently is you're going beyond what I thought the intent of this code section was. Now, I'm willing to be corrected.
Like a lot of things in life, there may be degrees of negligence also. And I certainly think that maybe there's a negligence penalty that would, once again, have to be above 25%, and maybe there's a separate for bad faith. Because I do recognize the chairman's concern here that I think there's degrees of conduct. But at the same point in time, there's got to be a proper incentive for a relatively, 25,000 is a minimum, and parties can opt out of that. They're not required to purchase, just like they're required to purchase $25,000 of liability. They're not required to purchase $25,000 of because they can opt out of that coverage. But if they do choose to purchase it, and then a demand is just not responded to, that meets the statutory requirements, and there's proof that it was received and it's not responded to, there has to be a penalty greater than the current penalty.
Thank you.
All right. Mr. Snipes, I don't see any other questions for you. Thank you.
Thank you.
All right. We're going to move on to the next measure.
Can I give a final?
Oh, yeah. Sure. Representative Gallup.
Thank you. So, I just want a final statement here. When I make a mistake, I'm responsible. When the insurance company makes a mistake today, they're not responsible. And I actually think that they're actually immune to their own negligence today. And this bill fixes that. This bill helps Georgians. And I appreciate y'all's time hearing it. Thank you.
Thank you for bringing it to us. We have two more measures to come before us, but before we get to those, I apologize for my negligence in not recognizing her earlier. Judge Brenda Weaver is with us. Judge, thank you for being with us. You're kind of shielded from me a little bit here, so I apologize for not recognizing you, but it's always great to have you here with us, and thank you for the work that you do.
I've enjoyed the discussion.
Yes, ma'am. Thank you so much.
Judge, I think we should penalize them.
I'm sure I will get my due penalty, Mr. Chairman.
How many days for contempt do you suggest?
All right. We're going to move on now to House Bill 1108. Representative Burchett.
Thank you, Mr. Chairman and committee members. We've got a simple, easy, quick bill here for you. What 1108 does is it deals with some ambiguity within the code, and it pertains to settlements for minors. There are some. This bill was brought to me by the state court judges, and Bob Bray has been helpful, and we've been working in tandem with some of the other parties to get this language right. And Bob, if you come, thank you. Come on up. What we've done here is we've added a definition of net settlement in Section 1, and that was really just to clarify the definition of gross settlement, as I understand it here, taking out the attorney's fees and expensive litigation as it pertains to a settlement to a minor. The bill deals with how and when a conservatorship is necessary by the probate judge or probate court as it pertains to a pending litigation in Superior Court. And I got a little cheat sheet here I'm going to run by you guys. If a gross settlement is $15,000 or less, no court approval is required. So it doesn't need probate or Superior Court. If the net settlement is $15,000 or less, no conservatorship is required. That's Section C as well. In Section D, if the gross settlement is greater than $15,000 and no action is pending, probate court approval is always required. That's Section D. Section E, if the gross settlement is greater than $15,000 and an action is pending, only trial court approval is required. And that's really making the process a little more efficient. If you're already in Superior Court and the settlement's at $15,000, there's really no need to go down to the probate court and open up a new action to get approval of the settlement. Number 5, in Section F, if the net settlement is $15,000 or less and an action is pending, the trial court can approve without a conservator or probate court action. Section F. And Section G, if the net settlement is greater than $15,000 and an action is pending, both trial court approval and a conservator from probate court are required. I will also add that there are on lines 24, before the word "the," we need to insert "if." On lines 29, before the word "legal," we need to insert the words "if no," and strike "notwithstanding whether." Also on line 29, after the comma and before.
I want us to have a policy discussion, and then let's look at maybe moving towards a markup, because I have some thoughts of another way to do this.
Certainly. Well, I'm open to questions, and I'm certain my witnesses are as well.
All right, Mr. Bray.
Hi.
Why don't you speak to us about the measure here?
Thank you very much, Chairman. My name is Bob Bray. I'm the Executive Director for the Council of State Court Judges. And if I may, when Representative Burchett was offering the Superior Court, the state courts also handle these cases too. I'm not an attorney. One of our judges who saw this as an issue wanted to be here, but he's in Chatham County, so I'm not an attorney. I'm sort of reporting and doing the best I can with this. If you get in the weeds, I may have to rely on Judge Weaver maybe to to help if I get too tangled up. But what they saw was an issue, some confusion with both judges and attorneys when they applied the statute that deals with claims to minors. And so they decided that it might be easier just to clean up the statute a little bit, and that's all this is really doing. Right now, the limit is 15,000. That's the trigger point. If it's less than 15,000, then the natural guardian usually can go ahead and receive the funds. If it's more than 15,000, then we want some other party to oversee those funds. From what I understand from Judge Fowler, Judge Sapp, is that in a lot of these cases, when an offer is made of settlement to the minor, that they involve an annuity because they aren't receiving the funds right away. They receive the funds when they either become 18 or ages at certain ages. So that's why you have this particular thing. And the problem I think that was occurring was that how do you get to that $15,000 amount? And so that's what clears it up here. The amount that you use for net actually already exists in the statute. It already appears on lines 53 through 56, which have been crossed out. And they've just taken that and rearranged it up here and put that in as what net settlement is, so that when we have these distinctions, you can see the differences. That's about the best I can do on that one.
So with a fair characterization, and help me walk through this, how much of this do you think is just cleaning up the language to help do that and point out specifically to us the policy changes that are made in the bill?
Well, I haven't seen any real different policy changes because you're still wanting conservators to oversee funds when they reach a certain amount. So I really don't see any policy change in that respect.
One thing I've seen in my practice, and I'd be interested, to hear others' opinion, is as insurance levels has changed, as settlements have changed. I've gotten frustrated at different times about the level of being $15,000. Do you have any thoughts on that?
No.
In fact, I had a bill that would move it up to $25,000 a couple years ago, and I would be very tempted to include it in this bill to strike every place that says 15 and move it up to 25,000 as well. Do you have any thoughts on that?
I don't think I can speak only for the state court judges, although we have worked with the probate judges on it, and it is a judicial council bill. Our judges don't really have a problem with that at all. I think, though, if you do that, there is reference here to a statute 29-3-1, and if you're going to change that amount, then you'll probably need to add that as part of this bill too to make that change.
Okay. Thank you, Judge Weaver. Did you have any thoughts on that?
The bill itself was approved by the Judicial Council, so I would hate to agree to change the amount without going through, or at least having contact with them tomorrow on
Okay.
this. I personally, speaking for myself, do not see that as an issue.
I've just seen so many settlements get held up at extended times in probate over what's still $25,000 is still a relatively low amount there. But I understand that y'all have worked within the council, and I don't want to ask y'all to do anything either to disrupt that balance. Thank you. Representative Oliver.
I do some of this work, and I'm asking Judge Weaver this too. On line 44, the settlement must be approved if it's less than net's less than $15,000. I'm really thinking we're taking away the authority of the Superior Court judge of the state of court. And what if the judge really felt like this was a $100,000 claim and this family, unrepresented, is being bamboozled? I'm just focusing on this must be approved. That confuses me a little bit because I know judges that will look at a settlement and say to this family, you have $25,000 of medical expenses here.
If I may, that.
Of course, I would think that we would want some discretion at that point in time.
Judges usually want discretion.
We do. Anytime it says it must be, it would be really good if we could look at the facts of the case and at the family to make a determination as to whether or not that should be, you know, sometimes we might look at the family and say at 25,000.
Lucky
knowing
you.
this family, we might want
Right.
somebody to be able to look at this, particularly in rural areas where we know the people. So,
That's the only thing that bothers me.
Okay.
In terms of the raising the amount to 20 or 25, I think that's economically fair to the family, but again, it's relative. Does $25,000 is a huge amount of money to some families.
And we always struggle when we set dollar amounts in
Right,
code to need
right.
to revisit them at times. And I can't remember exactly when we set it at 15, but I seem to remember it was
10-ish, 15-ish maybe.
like it was, because I was here, are you saying 10 or 15 years ago?
Mhm.
Yeah, okay. Because I know I think I revisited this in 17 or so.
Yeah.
And struggled there. Chairman, administration.
Just briefly, thank you, Mr. Chairman. In looking at lines 44 to 45, my understanding, or maybe my assumption here, is that there's confusion about which court to file to. So you've got your pending case in state court, and then you're filing this in probate court. It's which judge are you going to get this approved? And so this just spells it out, so it's very clear. And I was before you started, Mr. Chairman, on the dollar amount, I was going to bring that up and was curious what year that was passed. I'll pull the code in a minute and take a look. But I would join in the $25,000 threat. That just seems to make sense. And what we're really also seeking to avoid is court costs not eating up this plaintiff's money. You know, I mean, I think that's a real legitimate concern here. So, yeah.
All right. Thank you.
What you want is the family and the child to end up with most of the money, and it not be eaten up by attorney fees or court fees or things of this nature.
And those petitions are expensive. I mean, yeah. Mm-hmm.
But I'm still, I understand that it's either the state court can approve, but this says shall approve. That's what's.
I understand your concern about the judicial discretion. I tend to agree with you there as well. That would be something I'd also like y'all to take back to the council.
That shouldn't be a problem.
All right.
Because it is what Representative Estration indicated was the reason.
We will check on that.
Thank y'all. Representative Burchett.
Just so I'm clear, we're talking about the word must in 44, and we want to change it to a may. That would be give the judge some discretion. Is that
I
correct?
think when you're looking just back on line 33, is the
Mhm.
first instance I see. I think you would just go back, you would remove the strike and then take back out the underlined approved by. So I think you just say the settlement must be submitted for approval to the court in which the action is pending. And I think there may be some other areas where that takes place, and if so, we'd make them there too. Yeah, I see
Okay.
it. All right. Thank you, Mr. Bray. I know we also have Lyle Warshauer and Jordan Reed with GTLA, if y'all would like to come on up.
Thank you, Mr. Chairman. We appreciate y'all giving us the opportunity to come before you all day. And some of those ideas you were suggesting about the proposed settlement definitely seems to clarify some of the questions or concerns we were having. But one of the things is too is maybe there could be some clarity of saying what happens after the fact, whether to become a valid settlement or some language in there that makes it clear that it's proposed, and then once this happens, it becomes valid. So putting in that type of language.
Yes, I wasn't sure, Representative Oliver, your question was whether you thought that the language meant that the court must approve any settlement that's less than that amount. And I didn't read it that way, but I think if it could be read that way, Chairman Kelly had a good example of how that could be remedied. I think the reason we wanted to speak on the bill, and some of it's already been, it sounds like already corrected with respect to the discrepancies or the conflict between subsection D and E. I think that's been clarified. So if you either go to the trial court for approval or the probate court, but not both. And that is the one thing that we do, I don't want to say take issue with, but in real practice, it becomes problematic. You are in a trial court, you've had a judge that's been working on the case for sometimes years, has an understanding of the issues, the damages, and the parties. If it's, you know, a child that has parents that have been very involved versus maybe there already is a trustee or someone that is very competent in caring for the child's property in place. The judge might not think in that circumstance that it's necessary to then go to the probate court to get a conservator appointed. Even in cases that have larger value, where that is already set up in a trust and you've got a trustee, somebody that's already going to be accounted for in subsection 29.3.1, it's just redundant and it slows down the process. And this is a frustration to both plaintiffs and, quite frankly, the defendants and the insurers that want to close their files. These can be held up for a very long time if the trial court says, sounds great, I've looked through everything, approves everything, but we then have to go to another level to get the probate court. So our only real request would be that in the language that says in subsection G, that there would be some discretion for the trial court to pass this on to the probate court for the appointment of a conservator only when the circumstances make that necessary.
And if I could direct your attention specifically to lines 58 and 59, that would be the policy change that doesn't currently exist, that you don't have to have a conservator in such situations. So the idea would be maybe to, on line 59, after the word pending, you put a period, and then explain how the court could have discretion, something to the effect of such court may require a conservator of the minor approve such settlement.
And we'll certainly take those, y'all could get those amendments.
Right.
Maybe drafted up. You drafted an amendment judiciary before, Ms. Ruth?
I have. Thank you, Mr. Chairman.
All right, any questions for Mr. Reed and Mrs. Warshaw? All right,
Thank you.
thank y'all for being with us. All right, almost there. All right, the final measure that we have before this committee is House Bill 474. That'll be absolutely fine, Representative Kirby, and this is a measure that I know this body is not necessarily this committee, but this House has taken up. I know it had passed out of the Industry and Labor Committee, ended up making it to the Rules Committee, and somehow found its way back in Industry and Labor. And at that time, based on the committee schedules, we felt like this was an appropriate venue to send this to be thoroughly vetted. So Representative Kirby, will you give us just a short explanation? I know this has been thoroughly debated, so we are going to kind of keep things somewhat brief in all remarks today. But Representative Kirby?
Yes, sir, I certainly will. House Bill 474, and it's LC 364151S. Very simply, the intent of this bill has always been for two issues. Number one, the intent is the General Assembly makes law. And number two, when somebody other than the General Assembly makes law, what do? That's all it's about. That's all it's ever been about. It's not about changing anything in the rulemaking process of the State Board of Workers' Comp. Never has been. And what we did is we actually took what the board's doing now. They're by rule, where they make a rule and then they would give it to the Insurance and Labor Committee in the Senate and the Industry and Labor in the House. And if there was a problem, either one of those chairmen could request a hearing. And that's where it stopped. Once there was a hearing, nothing had to happen, and there was nothing else to it. Now, 9 months later, 8 months later, we could come back in the General Assembly and always pass legislation, or try to overturn it. But unfortunately, to address this, we had to go into a little bit of the process and try to disrupt it as little as possible. We didn't touch anything on the advisory council. We didn't change the process and how they make rules. All we did is add a little transparency and what I refer to as a pause button. How we pause this and stop it from going forward. And that's what we did. And if you look down through the bill, through lines 43 through 55, it's really just taking the current rule. The only thing it does is change it to add 30 days notice before the rule goes into effect. Right now, under the current rule, it could actually be the day before, so there wouldn't be much notice at all to react to that rule. Beyond that, then, if they have request a hearing, which they could do now by current rule, it does go into some public comment, views, or, make sure everybody, all the stakeholders, anybody wants to get involved can. Following that hearing, they're gonna produce a report, so there's actually something's gonna happen where it comes back to the General Assembly, that this is okay, to be reviewed. I don't have to tell this esteemed group here, the difference between a rule and a law can sometimes be a comma placement or a word. It can be very minor change that needs to be made. A lot of it could probably be just agreed on, and they have the hearing and put it right back to us. So it's not a change in their rulemaking process. Once that report's produced, if there's still a problem, if it still clearly looks like a change to the law or making new law, then it just pauses it till we come back in the next session. It doesn't go in effect. That way we don't have to worry about 6, 7, 8 months of the administrative law judges dealing with a law now that may or may not stay. And so we have during the first 30 days, a bill would have to be dropped in either the House or the Senate to move through the process. We put a very high bar on this. We said if it's 2/3 majority of both houses, it's done. It would stop that law from going into effect. If it just gets a simple majority, it still goes to the governor for signatures like any other bill would now. And really, that's all the bill is. It's entirely about making law and how do we put a pause button if a rulemaking goes beyond law. And the reason, the only other thing is, you all are probably aware of, 90-some% of our agencies and boards following the Administrative Procedures Act. The Board of Workers' Comp does not, and I don't think they really should either, but we're not pressing that issue. And with that, I'll be happy to answer any questions you all might have.
All right. Thank you, Representative Kirby. Chairman Efstration.
I know it's late. I'm going to be real succinct here. So if the board were to pass rules that maybe the General Assembly took issue with, could not the General Assembly then reactively file legislation or take certain action to address those rules?
The next legislative session, that's always an option to introduce any legislation. Of course, part of the opportunity that would occur with that is the Board of Workers' Comp is appointed by the governor, and the same governor you need to sign off on the bill that you passed to just when you think a rule is exceeding rulemaking going into creating new law.
So I guess my question is, has there been a specific problem with that occurring? And if so, is this in direct response to a problem that's occurred? If you can succinctly answer that.
Over time, yes, there have been rules that are actually changing law. 2019, very minor one, not a big deal, but it did change the law dealing with the posted panel of physicians. The rule says that if a doctor refuses to treat, then you can go back and add another doctor if they're associated, and I'd have to get it out to give you all the wording in it exactly right. But right now, or prior to that, you have your posted panel. We've got a right to change our panel, but if Joe gets hurt on Monday, you can't put a doctor on the panel on Thursday for Joe to go see. I mean, it really changed that. And quite honestly, most people say that's probably, as an HR manager, in my employer favor, and it's not a big change to the law, but again, we're not going to abdicate who makes the law to a board, an agency, a council, or a committee.
Thank you.
Chairman Fleming.
Thank you, Mr. Chairman. Representative, is this? I've seen so many iterations of this bill. I don't know what I'm looking at. Is this the same bill that passed out of Industry and Labor a week ago or less than a week ago?
Yes, it is. LC 4151S. Bill passed out of Industry and Labor.
Well, and what's the difference between this and the Administrative Procedures Act?
Well, the Administrative Procedures Act is.
Maybe I can clarify that a little bit for you. The Administrative Procedures Act, which the Workers' Comp Board does not fall under currently, has a procedure whereby the legislature can review rules and regulations made, and one of the committees of jurisdiction can stay it until the next legislative session. I read that in here, but I'm trying to figure out, is there a difference between that Administrative Procedures Act procedure and what this bill calls for?
Working with Legislative Council, we used some of the wording right out of the APA because we thought it set a good point to start with. We often refer to this as kind of APA light because when you get into the entire act, there's so much more that it encompasses that really doesn't need to be applied to the workers' comp.
Okay. So, Mr. Chairman, you want us to hold comments till the discussion part potentially, or you don't want to go ahead and do it now?
Why don't you hold until the end?
Okay. All right. Thank you, sir.
All right, we have a couple members signed up to speak. We have a couple witnesses, and we'll start with one of our members, Representative Carpenter.
Thank you, Chairman. Thank you for the committee. I always love being in this room. It's so nice and cozy. I know this bill because I've heard this bill 3 times in committee, and what it basically is doing is you're adding politics to an advisory board that doesn't need the politics. We've had this board for 20 years. It's operated as one of the best in the nation, and now we're adding politics to that. And so this timeline on this freeze basically, the rules usually hit the ground running on July 1. Basically, you could freeze that all the way up until February 6th, and then determine on how the House or Senate votes on that, it goes to the governor. Well, in that time, the governor could have changed after in November, and some of the House members can change in November. So you're actually putting the politics into that stay, and so that's the fear. Is you might have a rule that you want to stay, and then when it gets there, the whole politics of the state have changed, and I think that's a very dangerous and slippery slope. And it's, we always profess Georgia's the #1 state to do business, and we put it on our Facebook page. But when we do stuff like this, it retracts from it. So I would ask for.
Chairman Fleming.
I like you, but I'm going to ask you a question. The law already provides this legislature and the committees of this legislature under the Administrative Procedures Act to have review of rules and regulations made by executive branch agencies. There is a list of agencies that we don't get to review. The Workers' Comp Board is one of them. It is exempted from the Administrative Procedures Act. This piece of legislation in front of us would simply, as reference, be Administrative Procedures Act light. It would give us as a legislature the same authority we have over all those other executive branch agencies to stay and attempt to pass legislation if we want to overturn what an agency has done. I've actually participated in that once before when the Department of Revenue made some regulations that were very disruptive to the real estate industry. And we actually did stay that, and I think they backed up on it because they realized that we were bringing attention to a mistake that they had made. So you said this brings politics into it. Do you also think that all those other administrative agencies whose regulations we can stay, that meaning you can stay as a legislator, brings politics into it?
I think that the makeup of the Workers' Comp Board is completely different than the makeup of the Department of Revenue. And when you have an organization that has, hundreds of stakeholders in that industry together to make these rules, the dynamic is completely different than you have at the Department of Revenue in your case.
But you don't think this legislature should have legislative oversight over them?
And I think we would when we came back in January if we wanted to so pass a law out of the committee. But I think to tinker with this board that's working so grandly around the nation is a dangerous and slippery slope.
You did pretty good.
I've heard this bill 5 times.
Any other questions for? Let me ask Representative Carpenter this question. Should there ever be different leadership over the advisory board, would you, not looking at today, but do you ever think that it would be good to have a check and balance, to have the legislature have this oversight as a separate but equal branch of government?
So I understand your question, and I think what we've seen over the years is this advisory board has worked through since 2000. So it's been through Democratic leadership and Republican leadership, and that board, and it has managed to flourish through both. I think as you continue to do things to add more and more politics to that board that are already inherently there by an appointment from the governor, we're going to get ourselves in a sticky situation long term.
All right. The only other individual I see scheduled to sign up is Roy Bowen.
Thank you, Mr. Chairman, members of the committee. My name is Roy Bowen. I'm the president of the Georgia Association of Manufacturers. But I also have the distinct honor of being the chair of the Advisory Council to the State Board of Workers' Compensation. I've been involved with that advisory council since its inception. To your question about what bill, when the bill came out of committee, there was no reference to an LC number. The last time this bill was discussed in committee as a substitute, it failed to get a motion. So when the motion was made to come out of committee, it was simply HB 474. So I don't know what posture it really puts this bill in. That's something that you would have to determine. But it wasn't this LC number, nor was a substitute referenced. But I'll speak to the substitute because that's what's before you.
And I'm just going to place my faith in a chairman I have a lot of trust in, of Chairman Werkheiser, to not have done anything improper.
I'm not suggesting he did. I'm just saying it was never made clear what version was coming out of committee, and that this substitute did not get a motion when it was put up. This is, we believe, a solution in search of a problem. It's not necessary and undercuts what has, for more than 2 decades, been a process that has really served the system very well, the system stakeholders, injured workers, and the employers. I think Representative Oliver, I know, was here during the days when there was chaos in the system. Representative Smyrie was here. Not sure, Representative Fleming, if you were part of that or not, but you're lucky if you weren't. There was chaos every session involving workers' comp. This advisory council grew out of that chaos and the politicization of that, of the discussions that were going on. I would suggest that this legislation really does conflict with current statute 34-940 that says the board shall have the full authority, power, and the duty to promulgate policies, rules, and regulations for the administration of this chapter. I will tell you, in the time that I have been on this council, this advisory council, nor has the board, thought it was within their purview to make law. And there's been no example of that happening. This substitute, as many of you may know, is opposed by the entirety of Georgia's business community. There are a list of no fewer than 25 organizations, associations that represent employers in the state, as well as ACCG and GMA, that oppose this legislation. In fact, the only group that I'm aware of that is supportive of this particular bill is a component of the Georgia trial lawyers. I think that speaks to the confidence that the business community has in the system today. Again, the process that Mr. Kirby describes, this legislation, this bill, is not a mirror of the board rule that's in place today. There is a board rule that's been put into place that does provide transparency. It provides public input, and it provides the General Assembly an opportunity to send a rule back to the board for a public hearing.
When was that rule put into place?
The rule has been under development for some time and would have been put into place some time ago, but for the continuing efforts to try to bring everybody on board, that effort failed. The trial lawyers did not agree to the rule. This is an advisory body, but it's up to the board to make the final determination. So the board put into place a rule which Representative Kirby has, Chairman Werkheiser had. In fact, they've had a draft of it for some time.
Last week, right?
No, it's been before last week.
No, it was put into place last week.
Yes, sir.
To the chairman's question.
Yes, sir, and in fact, at the request of Chairman Werkheiser.
How does that rule vary from what we're doing in this piece of legislation?
In some pretty fundamental ways. The rule does provide for public notice. It provides for posting the proposed rule or amendment on the website. It provides 45 days, I believe, for public input. It requires that a rule, before it's adopted, be sent to the chair of the House and Senate Committees of Jurisdiction. And should the chair of either committee ask for a public hearing, the board is obligated to hold a public hearing on the rule. Now, this bill sets
But it would
up
not make any provision if the rule change was objected to.
I'm sorry?
It doesn't make a provision that if either the Senate Industry and Labor or House Industry and Labor Committee objected, does the rule that's in effect now or being proposed or went into effect last week, does it have any provision for what happens? I understand they get notice, but do they
Right.
get any ability to, what happens if they object?
I can tell you that there's been only one occasion that I'm aware of where a question was raised about a rule, and it wasn't all that long ago. It was raised and it was withdrawn because upon reflection, the board and the advisory council thought that it was not a good rule. It wasn't that the rule was trying to make law or overstepping the statutory authority of the board, but the folks that raised the objection had a valid point. Now, you know, should there be an objection to a rule that is put into place following public notice, following public hearing? Representative Carpenter is exactly right. An aggrieved party or a party that doesn't agree can come to the General Assembly with a piece of legislation. If they believe that the board
But
is
that's not typically what the advisory council wants us to do. I mean, right? I mean, if that,
Well,
I mean, I don't think we want anybody to go back to the chaos of running to the legislature to try and fix every problem in the workers' comp system.
Well, I'll say this: there's nobody has pointed out where problems are that needed to be fixed with this change in the way we have operated over the past 2 decades. I mean, there has been, not to my knowledge. So, but I do believe that this gives an opportunity for parties that, for one reason or another, are unhappy with what's going on at the board to come in and cause the kind of chaos that you're talking about. Now, again, when the General Assembly reconvenes, Representative Kirby or anybody else can certainly introduce a piece of legislation. And it could be that the board and others would disagree with that. But then it would be up to the General Assembly to decide whether Representative Kirby's bill had merit in terms of the statute or not?
Can we get a copy of that board rule by just as soon as possible, I guess, before the next meeting, or do you have one with you?
Yes, sir, I do. This is my copy, but
We'll just get copies made and get them back at the end of the.
and that has also been served upon the other respective chairman, as well as Representative Kirby.
Not really. They didn't give me one. Steel workers.
Well, I'll disagree with you on that.
So it seems like it does everything this bill does except give the legislature an opportunity to object at the time of.
It does provide for notice.
A request for
public input.
hearing.
Yes, sir.
Okay. Okay. All right. Anything else you'd like to add, Mr. Bowen?
No, sir, just that we've got a system that works well. We've got one of the best workers' compensation systems in the country. In fact, there are states that try to emulate what we do through the advisory council. It's fair, it's balanced, and these 110 people that serve on the council are admonished when they join the council. We love the perspective that they bring, be it from defense or plaintiff's attorney, medical, small or large employers, but don't bring personal agendas to the council. We're here to make this system the very best that it can be for our injured workers while being fair to the employers of the state.
And I appreciate the work the advisory council does, and that's one thing that I want to make sure we protect is the fact that I don't want there to be hurt feelings to start in April when the legislature's out of session, and then it fester until January when we come back to where we have members start thinking that they have to bring legislation outside of the advisory council. That's why I felt like, the ability for these committees to have the opportunity to object and maybe deal with it in the interim to keep cooler heads, allowing them to prevail. But
Yeah.
thank you for being.
Yeah, well, and if there were issues like that, perhaps I'd agree with you, but those just aren't the kind of issues that come up. I would suggest this, that there is a rule change. I mean, that we've heard the interest in having more transparency and public input and so forth. There has been a rule that's been adopted. I would suggest that you consider leaving the rule in place for a year. And let's revisit and see what kind of problems, if any, exist at this time next year. And then address them if there are.
Thank you for being with us tonight.
Yes, sir. Thank you.
Closing word, Mr. Chairman?
Absolutely.
All right. Like many of the hearings, we're trying to talk about law, and it quickly goes into rule and rulemaking. There's absolutely no other word in this bill about the advisory council, which is appointed by the board, the three-member board member. We're not changing anything about how they propose rules, how the board puts those rules into place, how they adopt those rules. We're not even talking about when we object to a rule. It's not about objecting to a rule. It's when we see a rule that's not a rule, it's creating new law or changing existing law. That's what we're trying to address. Not their rulemaking. Don't change that one bit. And to our colleague, Representative Carpenter, I have to disagree. I don't believe the General Assembly is too political to make law. I kind of think that's their job. And I don't want to abdicate that to anybody just because we're a political body. That is who we are. And it's all about lawmaking and not about rulemaking. And that's and then the final thing is we do talk to Chairman McKay at the State Board of Workers' Comp, and as of today, there's still not a new rule in place as of this moment. So, thank you.
Representative Kirby, how long have you been engaged in this discussion?
Approximately 5 years. As 474, the last, just this biennial, but we started several years ago talking about, You got rules like 200.2, which introduced a nurse case manager that has no real basis in law for that. Some might debate me on 240, but I don't believe it was correct either. I think it changed or created some new law. And again, it can be a matter of semantics, and as the legal profession knows, sometimes those little differences that where you all live and your arguments that you make in different court cases. So we don't pretend to be a lawyer, but we deal with workers' comp every day.
Thank you.
Thank you.
Appreciate it. All right, as we mentioned at the beginning of this meeting, we will convene again at some point on Thursday. Because I'm not sure at the time, based on our schedule on Thursday, we may convene fairly early in the morning. So what I'm going to say is any proposed amendments to any of the legislation that we dealt with today, I want that to be brought by this office no later than 5 o'clock tomorrow afternoon. And keep watch on your emails, because I'm not sure when we'll be able to jump into the schedule Thursday based on our floor schedule, or if we're going to be here to see the sunshine together. This is important work that we need to get done, and I do anticipate taking votes on these measures Thursday. Thank y'all.